What subject matter?
My lord,
Which bench?
compulsory retirement, my lord.
Compulsory. For orders, admission.
Actually, my lord, on last, my lord, 6/8/2025, my lord, a matter is listed for hearing, but due to lack of time, my lord, matter not be listed subsequently.
Hearing matters will have to be in the next month,
My lord.
October.
And next week, any date, my lord. And next week, any date, my lord.
Mm. 18th.
My lord.
18.
18. Obvious.
Next week. Giving it on 18 only this week. Yes.
May it please, Your Lordship. I beg to mention item number 34, Lordship. May kindly be taken up immediately after puja vacation, Lordship.
34.
Lordship,
Why?
we have obtained the consent of the respondents.
Why?
Lordship, my senior is out of station.
34. The request made by Mr.
I am R. Islam.
R. Islam, matter stands deferred to be listed after 4 weeks. Consent of the council for the respondents have also been obtained. Yes.
Lordship, I beg to mention item number 38, Your Lordship. Lordship, I am for the respondent, the petitioner, the consented.
Petitioner.
It may be taken up after vacation, Lordship.
Item 38 on joint request be listed after 4 weeks.
Obliged, Lordship.
Lordship, I'm praying for listing of a motion matter on Wednesday, Your Lordship, then APSC discharge matter, Your Lord.
Lordship, I beg to mention for withdrawal, Your Lordship.
Withdrawal
Yes, ma'am.
tomorrow.
Mass of the
I beg to mention for listing of contempt petition list on Thursday, pending,
Pending matter.
my lord. Just last listed on June 2024.
19th? Yes.
Lordship, today's hearing list item number 56. I'm praying for requisition of one affidavit in opposition filed by the respondent 2 and 3 here, Lordship. Today's hearing column, Lordship, daily list.
The hearing matter.
Yes, Lordship. 56,
All right, bring it.
Lordship. Obliged.
Lordship, I beg to mention one WPC matter for listing, my lord, on 25th September. It is regarding non-payment of pensionary benefit for admission.
Let it be after vacation, October.
If possible, my lord, one.
No, because last week could be motion miscellaneous matters.
My lord, one date may be fixed.
17th October.
May
Yes.
please do, Lordship, I beg to mention item number 19, Lordship. Now, pass over for the day, Lordship.
19.
19.
There's some office note. Item 19. Item. You have not taken steps. 19 on the request made by the council on the behalf of the petitioner.
Yes, sir.
Petitioner,
Petition.
your name?
M. Rahman on behalf of N. Ahmed, Lordship.
Mr. M. Rahman, appearing on behalf of Mr. N. Ahmed. Praise foreign is granted 4 weeks' time to take appropriate steps.
Yes, sir.
Yes.
Lordship had taken up few FPSC matters on 20th of August. In those orders were passed, 3 of the orders. In 2 of them, correction is called for. Sir. Lordship, I have prepared the corrected copy, or am I to file an IA?
You make a mention for tomorrow, we'll correct.
I shall inform Mr. Nath.
Please inform.
Daily list item 1.
Corrections.
May I please, Your Lordship? Lordship, this is for non-compliance of the order dated 2/4/2025. The operative portion of the order is at page 17. Para 9. Under the circle.
Yes.
Under the circumstances, this court is of the considered view that the benefit following out of the said decision of the Madras High Court, which in fact was decided on 15/9/2017, cannot be denied to the instant petitioner. Accordingly, both counts, the court finds merit and the amount deducted as stated herein above be refunded to the petitioner, and the respondent shall also grant admissible increment to the petitioner by making a required calculation.
Well,
Such an exercise should be undertaken.
Then you filed an representation
Yes, Lordship, and there's representation disposed of by order.
rejecting it.
There's, yes, Lordship. At 35/2025, that is at
Right.
page 22.
Third, learned counsel for parties issue notice. Returnable 4 weeks. Steps on respondents by registered post AD as well as usual course within 1 week from the date.
No. I can do.
Please allow. My lord, the petitioner was placed under suspension by page 53, my lord. On.
Some instructions were.
Yes,
required.
Lordship, instruction received, Lordship,
Ah,
not reviewed.
Not.
not review. Why? What is the status of the proceedings?
Uh, Regarding the status, Lordship, it is not stated in the review, Lordship.
When was he suspended?
Page 53 on 10th February 25.
February 25.
My lord, at
Then-
page 53.
Then no proceedings.
No proceeding, nothing.
You file your affidavit.
Lordship,
This is contrary to your own circular.
Lordship.
Heard, Mr. J. Barvia, counsel for the petitioner, Mr. J.K. Goswami, additional senior government advocate for the state. Mr. Goswami on instruction submits that he has received complete instructions from the respondents and would like to file an affidavit. He fairly submits that no review has been undertaken pursuant to the petitioner being placed on suspension. He prays for 2 weeks' time to file the affidavit. Let the affidavit be on record. This again after 2 weeks.
Date may be.
We are issuing notice.
Lordship.
Issue notice
Lordship.
returnable after 2 weeks.
Lordship.
Since
Well, the
Mr.
date may
Goswami, appears for the respondents, notices are waived, extra copies will be furnished within a period of 1 week,
2 days.
if not already submitted.
Already I have served, my lord, even though I'll. serve.
One copy, sir.
15th, you can have it on 15th October.
Lordship.
I can read.
But the matter relates to promotion of the petitioner from ACF to DCF. On last occasion, your lordship may kindly see the order dated 12/8/2025. It was submitted by the learned counsel for the response.
Yes, Forrest, any instructions?
The petitioner's name has been forwarded for next DPC, my lord. But when the next DPC will be held, we have put that inquiry, my lord. That answer has not come yet. But in the next DPC, my lord, the petitioner's name will be.
That is the difficulty, because if your lordship perishes page number 31 for a moment, there is a letter dated 2/1/2025 issued by the respondents themselves, saying that the DPC would be held on 3/1/2025. So for the last 7 months, 8 months, lordship,
No DPC.
no DPC. So if there is no instruction that when the DPC can be held, if your lordship dispose of this petition, fixing a time frame to respondents,
How can we do that?
lordship. Otherwise, lordship, it will be very
How can we do
difficult,
that?
lordship,
How can we fix a time frame for the department?
lordship.
Unless it is specified in the rules or
No, it is not
Sub-notification.
specified in the rules. That
Then-
is the difficulty.
Then
Because this will go on and on, Lordship.
why the DPC is not being held? How many officers are being considered? And for how many posts?
There is a list of 21 officers.
No, 26. 26, at page number 23 and 24.
Where is the name of the petitioner?
No, his name is not there. This is the last DPC wherein the other colleagues of the petitioners were promoted from ACF to
They
DC.
have all been promoted.
Yes. And if your Lordship peruses page number 32 for a moment.
52,
32, Lordship.
32.
32.
Hmm.
32 post at serial number 3, as your Lordship found. Post of DCF AFS vacant as on 2/5/2025.
Hmm.
32 posts are vacant. In spite of that, they are not holding DPC when there are posts are vacant. And tomorrow they will say that they run short of officers to run the department.
Why there is no clarity when the DPC will be held?
Well, we have informed the departmental head, but nothing has been.
How many officers are to be considered?
As per our, the fresh list, my lord, 21 names are there. Petitioner's name is also in that list.
In fact, in my respectful submission, all those 21 persons could be considered because 32 posts are still vacant. Even if those 21 are filled up.
Heard counsel for parties, Mr. I. Botakur, standing counsel Forest on instructions, submits that the petitioner's name has been forwarded for consideration by the DPC for promotion to the next higher post of
Deputy Conservator of Forest.
Deputy Conservator of Forest. However, no date for as yet has been fixed for fixing up the DPC. Although Mr. Botakur submits that instructions have been sought for, they have not yet been furnished. We permit Mr. Botakur to complete instructions with regard to the time frame within which the DPC is likely to be held and apprise this court by the next date fixed. We are giving them some time, then we'll decide.
Lordship, already they took time so much. Lordship.
What is your prayer? What do you want?
Lordship, a simple prayer that you also will find at page 13. To hold the DPC, to promote the petitioner to the rank of next eligible rank.
They have already proposed to hold,
Lordship.
then we'll close it.
Sorry, Lordship.
We'll close your writ petition if this is your only prayer. Your prayer is to direct the respondents to promote.
Yes,
This promotion will be subject to holding of DPC.
DPC.
DPC will further assess your suitability,
Yes.
right? So they say that DPC will be held. Is there anything under the rules to say?
No, there is nothing under the rules, but this court can always expect that the DPC can be held within a short period of time. Otherwise, this petitioner who is suffering for the last 2-3 years, this will go on, Lordship.
Therefore, we need instructions to find out what is the
Lordship.
department's intention to do.
Yes. If your Lordship fixes this matter just before the day of vacation.
No, it has to be after vacation. List taken on 17th October.
Lordship.
Understood.
May it please your lordship.
Hmm.
My lord, this case relates to the voluntary retirement of the petitioner from service, your lord. Now, from my lord, Annexure 1, page 13, your lordship will find that this is the appointment letter of the petitioner, and your lordship will find he has already completed more than 25 years of service. And Annexure, my lord, 3 at page 17, your lordship will find that he is more than, my lord, 50 years. And if that be so, your lordship, then he is entitled to voluntary retirement under FR 56C. Now, in the meantime, from Annexure 3 and 4, your lordship will also find that the petitioner is suffering from mental illness, your lord. And despite all this, my lord, knowing fully well, my lord, they had issued a show cause notice, your lordship will find at Annexure 521, my lord, initiating that departmental proceeding against the petitioner for alleged unauthorized actions, your lordship. And in view of this, my lord, your lordship will find at page, my lord, 25, he has submitted his application for voluntary retirement. Despite all this, my lord, they had again issued the notice, your lordship, Annexure 7. Now, all these, my lord, are against the decision of the apex court, your lordship, Dinesh Chandra Sangma, Manjusri Pathak, then Vijay Sathe, and all these, your lord. So, my prayer will be, my lord, let the notice go in the meantime, and my lord, in the meantime, your lordship may kindly see, my lord, page 11. And this show cause notice and department.
Where is your medical certificate? Medical opinion that you are suffering from
Mental illness, your lordship will find, my lord, Annexure 3. Then they are referring the petitioner, my lord, to the medical board and all that one.
Then?
State medical, so my lord, next your lordship will find mental, second paragraph, my lord, second line for treatment for mental illness. And Vijay Sathe's case, your lordship will find, my lord, Vijay Sathe versus Indian Airlines, my lord, that in a case where the person has decided to resign or to go on voluntary retirement, your lordship, and all that, this unauthorized absence in initiating of a disciplinary proceeding against the petitioner, my lord, these are all redundant, your lordship. Your lordship may kindly see this paragraph.
You have not enclosed any document to support your contention that you are suffering from mental illness.
They are, my lord, sending me to the medical board.
That's
and
right.
Ultimately, Annexure 4, your lordship find that there is an award mental illness, your lordship.
No, stated like that.
Annexure 4, your lordship will find.
We'll issue notice here.
Yes.
Right, Learned Counsel.
This is their letter, your lordship.
Returnable 4 weeks.
With reference to the subject cited above, I have the honor info that yes, Devashish Rai, as per record, was under your treatment.
We are issuing notice. We are issuing notice. Mr. K.K. Goswami, Learned Additional Senior Government Advocate, he is an exception notice on behalf of our respondent.
All the respondents.
As such, notices are waived, however, extra copies we furnished within a period of 1 week. List accordingly after the returnable date. We are issuing notice online. Right. Let them come up with their reply.
He likes to go for it. Why to retain him, my lord, in this, when he has decided and he cannot attend the court, my lord office.
Therefore, we are issuing notice.
But in the meantime, my lord, the disciplinary proceeding, I do not know it will proceed. And ultimately, he will be, my lord, dismissed from service. And my lord, he will not be getting his voluntary, my lord, pensionary benefits. That is what is going to happen here.
Proceedings initiated against the petitioner, if continued, no final decision be taken by the respondent authorities without leave of the court till the next returnable date. Any instructions?
We are expected to get instructions by tomorrow, my lord.
None appears for the petitioner, list next week.
Okay.
Mr. Rai Gorkapur for this forest.
6.
Yes.
The civil proceeding, my lord, penalty has been imposed, reduction of rent. And the reason is that I took a loan from some individual, my lord. I failed to pay certain amount, my lord. There was dispute regarding interest. But they say that they defamed the police headquarters. How can it be, my lord? Yes. The charges are, you will take, my lord.
You filed appeal also.
Appeal was also dismissed, that last order, my lord, will
We'll issue notice here.
Yes, sir.
Mr. P. Court of Appeal.
Cannot be
The
misconduct.
petitioner issue notice returnable 4 weeks. MS S. Borua, Learned State Council,
Yes, Lordship.
appears on behalf of 1, 2, and 3.
Yes.
All, my lord, they are there.
This one.
All.
All, my.
One is by name.
4.
Oh, also, well, he's the inquiry officer, actually.
But he, by name is,
What? That's very by name.
I can appear only for 1, 2, and 3.
Okay.
1, 2, and 3. Therefore, notices are waived. Extra copies will be furnished within a period of 1 week from today. Steps on respondent number 4 by registered post 80 as well as usual course within 1 week from today. List accordingly.
Fixing your laws, that may be fixed.
Returnable 17th October.
7th, yeah.
List on 17th October.
7.
May I please your lordship? Lordship, my lord, in response to recruitment notice, my lord, Annexure 1, page 12, my lord, for the post of my lord, general duty for the recruitment of my lord, Central Armed Police Corps, my lord, for the year 2005, my lord. The petitioner offered his candidature, my lord, and appeared in the computer-based examination. Thereafter, my lord, he succeeded the computer-based examination, my lord, and an admit card was issued to him, my lord. That lordship will find, my lord, page 12, my lord. Thereafter, my lord, the petitioner underwent a physical efficiency test, my lord, and was found qualified, my lord. But, my lord, in physical efficiency test, my lord, he was surprisingly, my lord, disqualified, my lord, on the ground of height, my lord. His request, lordship may kindly peruse page 45, my lord. Just have a look, my lord. Page 45, my lord.
Yes.
Requisite height is, my lord, 165 centimeter, my lord, and his height is found, my lord, 164.7, my lord. But, my lord, before appearing this interview, my lord, lordship may find page 46, my lord, Annexure 4, my lord. He was appeared, my lord, another 2 interview, my lord, where his height was, my lord, found 165 centimeter, 165.2 centimeter, and, my lord, 165.5 centimeter in the year 2024, my lord. Page 46, my lord. So, my lord, after 1 year, height should be, my lord, increase, cannot be decreased, my lord. My respectful submission, my lord.
How do we know?
Medical certificate is there, my lord.
Where is the medical certificate?
Medical certificate is there, my lord. Lordship may find the medical certificate, my lord. Page, my lord, 51, my lord. Annexure 6, my lord. Certificate of physical measurement, my lord. Borpeta Civil Hospital, my lord. My height is, my lord, 165.5 centimeter. So, my lord, in my respectful submission, my lord, before your lordship, my lord, in similar cases, my lord, this honorable court, my lord, directed the respondent authorities, my lord, to consider the case, my lord, on merit, my lord. Lordship may find that order, my lord, at page, my lord, 52, my lord. May I read, my lord? Page
We
53.
have read it. We have read it.
Lordship.
We have read it. Yes. What do you say?
Lordship, third.
Appeal provision is there, Lordship. He can appeal
before
the
the
appellate
review,
authority.
review.
Yes, Lord.
I have filed, my lord, but
Where is it? Appeal?
annexure is not there, my lord, somewhere misplaced, my lord, but in para 4, my lord. Para 6, my lord, I have mentioned, my lord.
Para 6.
Lordship.
Appeal also, if appeal has done, then the result
What
of
orders
appeal.
were passed in the appeal?
Yes, Lordship.
Any orders passed?
No, my lord, till date, no order has been passed, neither I have been called, my lord. In similar case, my lord, I have recent order of this honorable court, my lord. In writ petition number, my lord, 5288, my lord, of 2025, my lord.
Simply this order was, has been passed, Lordship, but
Lordship,
his
kindly-
appeal is pending. What is the result? How can,
No, we dispose it off. In the event the appeal is pending, pass an order.
yes, Lordship.
In the
Yes,
event
yes.
some order has been passed, give him a copy.
Yes, yes,
Lordship.
yes.
Right, heard, counsel for parties. The petitioner before this court applied for the CAPF recruitment for the year 2025. Stop. According to the petitioner, his height is 165 points. What is your height?
My lord,
165.5 centimeters. Stop. However, in the physical test examination, his height was recorded as
164.7, my lord.
160. Where is that
Page
rejection?
45, rejection slip, my lord.
45. Was recorded as 164.7, and he was therefore disqualified as the minimum height required for male candidates is 165 centimeters. So, counsel for the petitioner submits that prior to this recruitment, he had appeared for 2 other examinations where his height was recorded as 165.5 centimeters. That apart, a certificate of physical measurement issued by the Superintendent Borpeta Civil Hospital, Olgasia, Borpeta, in favor of the writ petitioner reflects that his height, certifies that his height is 165.5 centimeters. Stop. Under such circumstances, it is submitted that the authorities wrongly rejected the petitioner on the ground of height by wrongly recording his height as below 165 centimeters. Stop. Learned counsel for the petitioner submits that although the copy is not enclosed to the writ petition, there is an averment in para 4 of the writ petition that he had, para 6 of the writ petition, that he had preferred a written appeal before the presiding officer, namely the respondent number 5, presiding officer of the recruitment board, namely respondent number 5. However, no order has been passed on the appeal, nor has the authorities permitted him have considered his case and sent him for re-examination or re-verification of his height. So, counsel for the petitioner submits that similar issues came to be disposed of by coordinate benches. Copies of such orders are enclosed to the writ petition. Para. MS.S. Borua, learned CGC, appearing for the respondents. All the respondents submits that in all the other matters, these coordinate benches permitted the petitioner therein to file appeal before the appellate authority. Stop. However, in the present case, he has already filed an appeal, and the status of the present appeal is not known. She submits that she may be permitted to complete her instructions on that matter. Counsel for the parties have been heard, and upon careful perusal of the writ petition and on due consideration of the submissions made, it is seen that the prayer of the petitioner is that his height, which was measured to be 165.5 centimeters by the superintendent of Borpeta Civil Hospital by issuing a certificate dated 26/8/2025, is the correct height, and his rejection by the respondent authorities that his height is below the specified below the height specified or mandated in the advertisement, namely 165 centimeters, is not correct. Stop. The petitioner has also claimed to have submitted an appeal before the appellate authority, which, according to the petitioner, has not been disposed of. Stop. Taking into consideration all the submissions made, this court is of the view that ends of justice will suffice if the writ petition is disposed of, directing the respondent authorities, more particularly respondent 5, to expeditiously consider the appeal stated to have been filed by the writ petitioner and pass a reasoned order, pass appropriate orders thereon. Stop. If in the meantime the appeal has already been considered and orders have been passed, then a copy of the said order be served on the writ petitioner. Stop. This exercise be completed within a period of 30 days from the date of receipt of a certified copy of this order.
Maybe allow, my lord, another price application to file, my lord, before the appellate authority.
No, you have stated.
That lordship, definitely, my lord.
You have stated you have filed. Have you
definitely.
filed or not?
I have filed, my lord. That
If you
might
have
be
filed, then
mistake.
why file another application?
Lordship, my lord. If that,
Disposed.
obliged, my lord.
Please, your lordship, the petitioner pursues an advertisement for election appointment to the post of junior engineer mechanical in the PW department, applied for the post, and he has been candidature has been he has not been selected on the ground that the academic qualification. The petitioner is a mechanical engineer, automobile. His subject is mechanical automobile engineer. And the mechanical automobile engineering, similar disciplines, they are under
Diploma holders.
diploma holder. So, my lord, in a similar circumstance, in earlier occasions, I have entrusted to the judgment of the two petitions, where, my lord, the junior engineer's diploma in the civil engineering and training was rejected to take into the diploma in civil engineering and also construction engineering. In both the cases, my lord, they formed committee, and ultimately, on the basis of the report of the technical education department, they have been directed, this honorable court directed for appointment them. So, my lord, at this stage, may I pray for a notice? Let them consider my prayer.
Have you filed any representation?
No, my lord, because my lord, ultimately my rejection is there at page 44.
What is your prayer? In that
Prayer, my lord, to constitute a committee like this earlier, my lord, the writ petitions. The education qualification was not taken. So on the same line, my lord, my prayer is there. There also they formed a committee and accepted.
Get instructions. Who's for the PWD?
I am for the PWD. At this moment, madam, I am seeking even notice, my lord. Let notice to my.
Council for parties issue notice, returnable 4 weeks. Mr. Radhor, learned standing counsel, represents the PWD department. Mr. P.P. Doctor appears for APSC.
Lordship.
And technical education? Who's there? Mr. J.K. Goswami appears on behalf of the Director Technical Education.
Standing counsel is there.
He's not here, you are there.
Copy was not served to them. That is the thing. They have-
All right, we are recording his name.
Yes.
Serve it through the government advocate. Steps on respondent number
5 to 10.
5 to
10.
10. Who are these petitioners? They're selected.
My lord, my lord, they have been selected, but not appointment. My instruction is.
Right, be issued by taking steps by registered post as well as usual course. 1 to 4 notices waived, no? Extra copies. Matter be listed after the returnable date. Counsel for the petitioner submits by referring to a judgment rendered by a court and bench in WPC 6311 of 2022. Disposed of on 23/4/2025 to submit that these in similar matters, the court directed constitution of a committee to examine the claims of the petitioner regarding their educational qualification, and upon such a report being rendered by the said committee constituted, the writ petitions were allowed. So, let the respondents complete their instructions and apprise the court on the next date fixed.
My lord, my one humble prayer is the interim is that at least one post may be kept.
No,
vacant.
Lordship, he has. No, my lord. Please continue.
One post, we do not know how many posts are there.
Let's say we recommend in the month of May.
My lord,
He has
he
come now.
belongs to SC community and there are vacancies also.
Not like that.
My lord,
Item 9.
Yes.
Okay, Deputy Commissioner Nalbari made an advertisement, page 24, for filling up of 18 number of posts of Lordship Latmandal. Page 24, Lordship, in excess 6. As per advertisement, Lordship will kindly see page para 7, page 25. Against each vacancy, 4 number of candidates will be shortlisted on basis of marks obtained in the written test.
Yes.
Thereafter, Lordship, the some petitioner has appeared and petitioner qualified in the written test, and Lordship, they were called for the computer test and other things. Page 28 is the list of the candidates invited for appearing for the computer proficiency test. Page 28. That is on 22nd March 2023. Thereafter, Lordship, some unqualified candidates approached this honorable court. Page 30. They have challenged that ratio of 1:4 was not maintained. Lordship will find the relevant portion, page 32. Grievance of the petitioner in that he, as could not seen from the written petition, is that there are 80 number of sanctioned posts of Latmandal under amalgamated establishment of Deputy Commissioner Nalbari, which were advertised by the advertisement. In the it is the case of the petitioner that as per clause 7 of the said advertisement, it has been mentioned that against each vacancy, 4 number of candidates will be shortlisted on the basis of marks obtained in the written test. However, by an order dated demand passed by Deputy Commissioner Nalbari, only 52 number of candidates were selected on the basis of written test. They have challenged that. Ultimately, that writ petition was dismissed by this honorable court. Finally, Lordship will find at page 35. I have perused the entire result sheet of 134 candidates, page 35, who participated in the written test as well as the marks obtained by the shortlisted candidate. The fact of the petitioner in who belongs to the unreserved category, there are 28 candidates who have been shortlisted against 7 posts. This does not find any reason to interfere in the instance of the petitioner herein. They could not question the selection of 28 candidates who were shortlisted against 7 unreserved posts in terms of the clause 7 of the advertisement. Consequently, instead petition stand dismissed. After dismissal, Lordship, in 2024, again on the same ground, selection was challenged by Firoz Samin Ahmed. This honorable court, by order dated 25/9/2024, page 37, on the same ground, remanded the matter to the authority to look into the matter if it is permissible or not. Lordship will find at page 37, middle portion, that since 52 candidates have been shortlisted for filling up 18 number of posts in ratio 1:4 as per requirement, the rule was not fulfilled. In this case, therefore, district administration has sought instruction from the government Assam to further steps as required to be initiated in this case. Lordship, thereafter, without looking to the earlier order, the page 39, in compliance of the order dated 25/9/2024, the government of Assam, page 39,
Yes.
I am last portion. I am directed to request to kindly to cancel the recruitment process and furnish all necessary relevant information to the Director of Land Record Survey Assam, who shall conduct a fresh recruitment.
You are one of the selected persons.
I am on the selected candidate.
Oh.
Now, Lordship, on the basis of this letter of the government, DC has cancelled. Being aggrieved, we have approached this honorable court because already the matter has been decided by this honorable court. Now they cannot decide that ratio is not maintained. Ratio has been, this honorable court has came to a finding that ratio has been not required to be followed. It has been followed in case of, Lordship, the unreserved candidates on the basis of marks obtained.
Yes.
Now they want to go
Yes,
fresh
Lordship.
election.
Kindly come to page 38, order of this honorable court. In view of the above, the writ petition stand disposed of by providing that the respondent shall take a decision in the matter at the earliest and notify the same. It will be open for the respondents either to pursue the present selection if the same is permissible as per the rule, or to go for a fresh selection process if so advised. And therefore, and on the basis of this order, Lordship,
Consequent order passed.
Revenue Department directed to go for a fresh recruitment.
Because this earlier order was not placed before
And
this
on the
honorable.
basis of that annexer 7, Lordship, page 39, Deputy District Commissioner passed this order.
What do you say regarding the earlier order? This has already decided the matter.
Yes, Lordship, the Revenue Department has directed to go for a fresh recruitment. Instructions.
Yes, revenue. Challenge made was already dismissed earlier.
But as per the case 37, Lordship, as per the instruction of the district commissioner, Lordship. Hence, this writ petition, sorry, Mr. T.C. Chutia Lanes Additional Senior Government Advocate Assam submit on the basis of written instruction dated 16. This instruction was received from the district commissioner. They said that ratio of 1.4 is not fulfilled. That's why that advertisement has been cancelled. But they have seeking instruction. On the basis of this instruction, we have issued annexer 11 of this page 39. On the basis of that instruction, we have written this letter to the district commissioner.
Everything has been done because earlier order was not placed before the authority. And that cannot be decided again by the authority. When court has this court has decided in earlier order. And this has been passed after inspection of the all records, earlier order.
Page 31, this petition was filed by some unsuccessful candidate.
That's right, but there is a finding that clause 7 is satisfied.
At least 7% that means 5. Lordship may issue notice, Lordship will take instruction, Lordship. Short statement given.
Hey, Mr. Goswami, the earlier matter was with regard to the challenge of
1:4.
some other candidates.
Who are not qualified.
No. They had challenged the selection made in respect of certain persons, reserved category.
Not reserved category. They are general category candidates.
General category, all right, unreserved. This was in respect of 7 posts.
7 posts.
So
We
the
are also
court
general.
found that out of 7, 28 candidates were shortlisted.
Shortlisted.
So therefore, 1:4 was maintained. In the subsequent matter, it is about filling up of 18 posts.
18 posts.
18 posts is advertisement post.
Ah.
Page, Lordship, again see, page 24.
24. Yes, 18 posts.
18 posts, and there are for general as well as OBC and other category.
Uh, Well, it heard Mr. Goswami, S.K. Goswami, learned counsel for the petitioner. Mr. S. Shaw, appearing for respondents number 1 and 2.
1, 2, and 3.
1, 2, and 3. Ms. S. Borua appears for 4 and 5. The petitioners before the court had appeared in response to the advertisement dated 1st of March 2023 for selection and recruitment to the posts of Lot Mandal. The total vacancies advertised were 18. And in terms of the said advertisement, against each of the vacancies, 4 number of candidates will be shortlisted on the basis of marks obtained in the written test. This is prescribed in clause 7 of the said advertisement. Mr. Goswami submits that in respect of selection of unreserved categories and candidates of unreserved categories, challenge to selection of 7 unreserved, 7 candidates belonging to the unreserved category. Some unsuccessful candidates that filed a writ petition being WPC 1751 of 2023. This petition came to be dismissed by order dated 4/4/2023 with on the ground that the writ petitioners could not question the selection of the 7 candidates against the unreserved posts, as 28 candidates were shortlisted in terms of clause 7 of the advertisement. Subsequent thereto, the subsequent writ petition was filed by selected candidate.
Selected candidate.
Was filed by another selected candidate, being WPC 1505 of 2024, and by order dated 25/9/2024, the writ petitions stood disposed of, directing the respondents to take a decision in the matter and notify the results of the said selection as it appeared to the court that 52 candidates were shortlisted for filling up 18 posts, and therefore the ratio 1:4, as per the requirement of the rule, was not fulfilled. It is the submission of the learned counsel to the petitioner that pursuant to the said order, subsequent order, the government by the impugned order dated 14/8/2025 decided to cancel the earlier selection. What is the date of the order? 28/8.
28/8, they are last deputy commissioner.
28/8/2025. Being agreed, the present writ petition has been filed. Learned counsel for the petitioner submits that the requirement of clause 7 in the advertisement, that is shortlisting of 4 candidates, shortlisting of candidates in the ratio 1:4, at least in respect of 7 vacancies for unreserved candidates, stood satisfied as per the finding of the coordinate bench by order dated 4/4/2023, passed in WPC 1751 of 2023. This order, however, was not brought to the notice of this court when the subsequent order dated 25/9/2024, passed in WPC 1505 of 2024, was issued. He therefore submits that the government by placing reliance only on the subsequent order without considering the finding of this court passed by the earlier coordinate bench by its order dated 4/4/2023, passed in WPC 1751 of 2023, would not have issued the impugned order. Being agreed, the present writ petition is filed. Mr. S. Doctor and Ms. S. Borua submits that they would like to complete their instructions in the matter. Accordingly, considering the issues raised, let notice issue returnable 4 weeks. The respondents may complete their instructions and file necessary affidavits in the matters, if so advised. Stop. Any fresh advertisement made?
No, they are going to advertise also. That is why we have made an interim prayer.
Till the next returnable date, steps for issuance of fresh advertisement in respect of the 18 vacancies of lot Mondal stock to be filled up.
It's a short notice, Lordship will take instruction instead of staying the process.
It's the same thing. As was earlier done by the advertisement dated 1st of March 2023, shall not be given, shall not be advertised without leave of the court. Matter be listed again. Give us a date when you want, when you can fix, when you can.
What date will we get?
How short do you want?
Immediately after vacation? Or
Immediately after.
Immediately after vacation is not a short date.
That's short. It will
Or before that?
List on 17th October.
Before that also, Lordship, can this before vacation?
We can
Before
fix
the-
it
before
tomorrow,
the-
day after, this week also, if they can obtain their
Lordship,
instruction.
before vacation, Lordship.
You give a date,
26.
26.
26th is the last working
No,
day.
26 I have difficult, Lordship. Then 24th, Lordship.
All right,
I'll try,
24th,
Lordship.
returnable on 24th. Yes.
Offline, Lordship.
Obliged.
I can tell.
My lord, in this matter, my lord, for promotion from grade 4 to grade 3, my lord, I made twice representation before the authority, my lord. And 23 and the last representation is pending. At this case, my lord, my only prayer, my lord, instead of going to the merit, my lord, my representation for the last 8 months before the authority concerned, my second prayer may be considered this case, my lord.
What is your second prayer?
Yes, my lord, at page 10, my lord.
Representations are
Yes.
pending.
Yes, but annexure 6 and 7, but last minute, annexure 7, 22nd January 25, that may be decide lordship whether I'm entitled for this post or not. That may be unspeaking order on that.
Have these representations been received?
Yes, my lord. In very next page, my lord, page 30. So let them decide, my lord. Then whether I'm only 3 years remain for my retirement, my lord.
Yes, Mr.
I'm not on merit at this stage.
May I submit, man? My lord will decide it. Why I'm telling my lord? Already division benches held by lord, no master roll worker. Those who are regularized to personal post cannot have a, my lord, promotion in the next level. That is the law as of today. Writ appeal,
This is the personal post.
personal post,
My lord, kindly have a look, my lord. Annexure 1, annexure page 16 first. This is my lord. Though I joined in the this is a regulation, my lord, in 2024, my lord. Lordship will find my name at paid in next page, page 13. Serial number 13. Stolen Bordol, my lord, and the Titabo Road subdivision, that is, my lord. The entry in the service that is shown 91. Do I have 91? But my lord, serial number 6, my lord. Serial number Kamala Dotto, my lord, kind note, my lord. Yes, together we regularized service. In the meantime, lordship. Annexure 3, my lord. Annexure 3, page 22-0. 14/5/2010, my lord. My name is at serial number 6. With altogether 7, my lord, the master worker been promoted temporarily to the lower division assistant, senior assistant, my lord. Page 20, my lord. My name is at serial number 6. Then lordship will find, my lord. Annexes 4, page 22. Subsequently, my lord, another order passed on 30. That means initially they have promoted me to the grade 3 post. Then there were 31/7/2010. Again, they, my lord, the earlier order, they, my lord.
To cancel.
Yes, my lord. Then, my lord, page 25, Annex 5. That is on 22/12/2015. Lordship, in by regulation order, the serial number 6, I from name Kamala Datta. Our services has been regularized on 22/12/2025, though we have same to 2024. Then, my lord, when this candidate has been regularized by the authority from grade 4 to grade 3, then I preferred in representation at page 27, Annex 6, my lord, to the executive engineer as per number 4, but it is not answered. Then, my lord, I waited for 1 year, my lord, then finally, my lord, at page 29, this is my last revision. I made all the references, my lord, but the authority instead giving any answer to my application, my lord, the sitting salary, whether I am entitled or not entitled as per the law, let them pass a speaking order on this point.
It appears to be, unless you say that this person at page 24 was appointed not on a personal post.
Yes, my lord.
My lord, the thing is that now division bench has settled. I cannot jump off a division bench, my lord.
When was this order? When was the order of the division bench?
2017.
Oh, this is prior to that.
Division bench has settled, my lord. Specific.
Dilip Talukdar.
Dilip Talukdar, my lord. Writ appeal 124 of 2015, 10/2/2017 is the order, my lord.
Writ appeal
24 of 2015. Order dated 10/2/2017.
124 of 2017.
You have a look, any judgment?
Yes, yes, lordship.
Para 12, my lord, specific.
At the request of counsel for the petitioner, matter stands deferred to be listed after 1 week.
Yes, my lord.
Come back.
Yes.
In address the court.
Yes. Obliged.
Item 11.
May I please, your lordship? Here in this case, the petitioner applied for the post of Anganwadi worker as per advertisement dated 22/11/2024. Annexure 1, page 14, lordship.
Yes.
After that, she appeared in the interview held on 8/1/25, and she was selected for the post of Anganwadi worker of Kol Malgaon by declaration result dated 8/5/25. Annexure 5, page 31, lordship. Her name was, she was selected and then her name was in serial number 9, lordship.
Will you
But-
should notice today? Will you should notice? Yes, Mr. Biswas?
Yes, yes, ma'am.
Heard the counsel for the petitioner. Issue notice returnable 4 weeks. Mr. Basumatari.
Sorry, R.K.
Mutari. R.K. Musari appears on behalf of
Respondent number 3, 4, 5, and 6.
3, 4, 5, 6.
I'm for 1 and 2.
A. Chakraborty for respondents 1 and 2. Since the council represents respondents 1 to 6, notices are waived, extra copies be furnished within a period of 1 week from today. Steps on respondent 7 by registered post AD as well as usual course within 1 week. Listing up accordingly after the returnable date.
Lordship, pendency of the case should not be considered.
Pendency of the writ petition shall not be a bar to consider the prayers made by the writ petitioner.
Item 12.
Yes.
Wait, Lordship. No, petitioner in this case, my lord, has few prayers.
Recovery.
My lord,
Recovery from overstay.
my lord.
Is
The
it-
interim
is it-
order, page 44 and
Is it
41.
included in Rafiq Mercy?
Traffic mercy, my lord. Clear, clear, clear,
Is
clear.
the judgment available with you?
Yes, ma'am.
Let us have a look.
Whitewash. Last paragraph, my lord, sub-para 1 and 2.
These are regarding pay fixation. Wrong fixation of pay, salary, but not overstay.
No,
Your case
here-
is a case of overstay.
This is a case of what has happened, my lord. They extracted my service. There was no notice. On the last day of my retirement, my lord, they issued this letter.
So
On
we'll
30th of June.
issue notice.
At this stage, my lord, notice. But otherwise, I believe, my lord, I am covered by Rafiq Masih. Let notice.
Covered by Rafiq Masih?
Right.
Perhaps not.
Well, let them come. now.
Perhaps not, because this is with regard to where some pay scale was wrongly fixed, allowed to you. You had received it without any fault.
But here
is a case where you
my
had
lord,
overstayed.
here what has happened, my lord? They asked
We'll
me-
examine it.
Yes, my lord, let notice go now.
Heard Mr. P.D. Goswami, Director Counsel for the petitioner, issue notice, returnable 4 weeks. There is no standing counsel.
No, my lord.
Steps on respondents by registered post AD as well as usual course within 1 week from today. Do you want to take Dusty?
No, let register also. At this stage, my lord, I believe the officers are scattered in Guwahati itself, my lord, regional and divisional.
You want to take Dusty? No.
No, not at this stage. Within 1 week, huh? No. Much obliged, my lord.
May it please, my lord.
Yes.
Prayer for compassionate appointment, my lord.
Compassionate.
My lord, pursuant to the court's order, this is a court's order, my lord, my name was recommended for the DLC, my lord.
Your name was?
Recommended for the DLC, my lord.
Ah.
My lord, may kindly have page 24, my lord, for a moment.
There is some executive order which was passed.
Yes, my lord. My lord would kindly have it at page 32, my lord.
32.
Yes, my lord.
Yes, so
My lord, in light of the Achyut Ranjan Das case, my lord, I am stating that my case should be considered, my lord.
no. See, what does the executive order? Your case falls under which category?
My lord, my case, my lord, I was not a writ petitioner in Abdul Qadir Bakshi, my lord. I was not a writ petitioner. However, my lord, that essence, my lord, of Abdul Qadir Bakshi, because I am now challenging the OM of 24, my lord.
Then we'll issue notice here. That counsel for parties issue notice returnable 4 weeks.
What?
Mr. H. Chakraborty, APS 4.
1, 3, and 6 lots.
Respondents 1, 3, and 6.
My lord.
MS G. New, APS 4.
2, 4, and 5.
2, 4, and 5. Yes.
Lordship, may I kindly submit one last thing, ma'am? My lord, actually, my lord, as per this executive order, my lord, today is the last date, my lord, where recommendations will be sent, my lord. Lordship has.
You have to show us which category you fall.
My lord, I fall under this category, my lord. If lordship has page 32 for a moment, my lord.
Yes.
Yes, my lord, those guidelines of the state government and judgments passed by the Honorable Supreme Court of India and Honorable High Court. My lord, para 7 of the order dated 3/8/2006 in WPC 3875 of 2005, Achyut Ranjan Das versus State of Assam, my lord.
No. You are referring to page 32.
Yes, my lord. Annexure 9. Annexure 9, my lord, bottom portion, my lord.
All right.
My lord, here, my lord, in the table, my lord, that has been set forth, my lord, para B, my lord. Para B, guidelines of the state government and the judgments passed by the Honorable Supreme Court of India. My lord, I am relying on this, my lord, B, my lord. I am saying that my case is covered under Achyut Ranjan Das case, my lord. Because, my lord, the authorities did not sit over my case during the relevant time, my lord. Otherwise, my lord, Achyut Ranjan Das is very clear on the law, my lord. Because of them, my lord, my case
Yes,
was...
Lordship, here, Lordship, her father died, Lordship, on 2006, Lordship. After 15 years, Lordship, they applied, Lordship, for a compassionate appointment, Lordship. And after the 16 years, Lordship, they approached before the Honorable Court, Lordship. In compliance of that order, Lordship, the DLC recommended on 23, Lordship. In the year 23, Lordship. That was purely covered by Debabrata Tiwari case, Lordship.
My lord, today, my lord,
And a new SOP was also issued, Lordship.
My lord, my respected senior, what my respected senior is saying, my lord, pursuant to that, I would just like to state, my lord, at page 24, my lord would kindly have page 24, my lord, for a moment. Annexure 6, my lord. This is the DLC recommendation, my lord. I was placed at serial number 5, my lord. May I read, my lord?
DLC
Placed in the
recommended was
DLC
in
meeting-
compliance of the Honorable Court order,
Honorable
Lordship.
Court's order. My lord, if today my case is not placed before the SLC, my lord, I'll lose out the chance, my lord. Today is the last date, my lord, 15/9, my lord, as per the executive order, my lord. If, my lord, I don't have a case, they may cancel, my lord. At least, my lord, my case, my name would be recommended, my lord. They can cancel if.
Why have you come today in the last day?
Lordship.
What were you doing for all these days?
Well, I apologize for that, my lord. But
So your apology doesn't help you.
my lord, kindly, my lord. If I don't have a case, they may reject, my lord.
No, 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 no. It's
By the
not like
DLC, they
that. You
reject.
have to first make out a case that you have a case, inviting a direction from this court.
Yes, my lord. My case is that, my lord, as per Achut Ranjan Das case, my lord, the DLC should preside twice, my lord.
Once the DLC recommended your matter, what happened after that?
Thereafter, my lord, we were under this expectation that our case would be considered before the SLC, my lord. We were
For
waiting.
2 years, you were under expectations.
My lord, 7/7/23, my lord.
7/7/23, then what happened after that?
So thereafter, my lord, every time we would be given verbal assurances that, my lord, it would be considered, my lord. That is why, my lord, we were also having a legitimate expectation only, my lord. That is since it was in the due process, my lord. That is why, my lord, we didn't approach before, my lord. That is our case, my lord.
So compensation appointment is not a matter of right, Lordship. Father died, Lordship, in 2006, Lordship.
My lord, yes, my father died in 2006, my lord. But today, my lord, my case was placed before the
He
DLC. my
survived,
lord.
Lordship.
Oh, my lord. Somehow, my lord. Kindly, my lord, if it is placed. They may reject, my lord, after that. At least I may get a chance, my lord. Since I was having this expectation, and the authorities had given me that
Please
expectation.
explain to us how this executive order is to be worked out.
Lordship. That was issued on 30 August 2024.
That we can see.
Lordship.
Now, what you have classified these
Lordship,
cases.
in the bottom portion of Lordship, 2 Lordship, Roman 2, application cases pending before the DLC and SLC. It is pending is SLC, Lordship, wherein OM dated 18/9/24 has not been put to challenge before the Honorable High Court as on 3/4/25, Lordship, and after 3/4/25 shall be dealt with terms of OM dated 18/9/24, Lordship. That was applied in 18/9/24 and shall be disposed to intimate the applicants to the respective DLC and SLC as per the case of order dated 3/4/25 passed in WPC 342/25 shall not apply.
No, this is as far as number 2 is concerned.
Lordship 2 is concerned.
What happens to 1, Roman 1?
Roman 1 is Lordship. It was not pending before the DLC or SLC. Roman 2 is pending before the SLC or DLC, Lordship. Here is, this case is pending in SLC, Lordship. Roman 2 is applicable in this case, Lordship. And that was and it was covered by the state of West Bengal by the Debabrata Tiwari. Here the para C is.
My lord, but the authorities have also included Achut Ranjan Das, my lord.
In
They have
Achut Ranjan
only-
Das, the Lordship, it is also not applicable, Lordship. Why, Lordship? They have approached before, they have not filed in 2006, Lordship, died in 2006 and applied in 2021, Lordship, after a gap of 15 years, Lordship. How it is applicable, Lordship, in Achut Ranjan Das case, Lordship?
My lord, if that was the case, my lord, they shouldn't have placed my case before the DLC.
You fall under category 2. You have not challenged the office memorandum.
I have challenged, my lord. My
Now
lord would
challenge,
kindly have,
Lordship.
my lord would kindly have page 7 of my writ petition, my
That
lord.
SOP is not challenged, Lordship. That 30 August, Lordship, in
SOP I am not
2003 was
challenging, my lord. I am saying I am squarely covered under the executive order. That is the SOP. I am challenging the OM of 24. Why should I challenge the SOP and covered under the SOP?
And that falls under the SOP, Lordship. That case was covered by the Debarputta Tiwari, Lordship.
Achut Ranjan Das is also there. They have included, my lord. I have not
They
included.
fall under category one.
Yes,
Two,
my-
Lordship.
How?
As per the pending in SLC, Lordship. DLC recommended, Lordship, here. On
Well,
seven,
why don't you-
on
why-
seven,
why don't you
23,
read-
Lordship, DLC recommended.
Please read clause number 1 first. Read it aloud for all of us.
All documents, information received in respect of the cross compassionate appointment from the petitioner who have challenged office memorandum dated 18/9/24, including the similar case which has been disposed of Honorable Guwahati High Court, citing the judgment of order dated 3/4/25, passed in Honorable Guwahati High Court case number WPC number 342/25, pursuant to the notice dated 38/25, issued by the personnel department and subsequently forwarded the personnel department to the respective DLC SLC, shall be considered and disposed the concerned DLC SLC on the merit by taking into consideration of clarification specified para 4 of this SOP and guidelines judgment mentioned column C and D in this case. In this case, Lordship, C and D are also applicable, Lordship. C is also covered by the here is state of West Bengal versus Debarputta Tiwari, Lord.
No. He's only says that his case should be placed before DLC. Whatever yardstick you want, you use it. And
Lordship, in this case, Lordship,
we are trying to understand the difference between 1 and 2.
Lordship, in my
In 1 is in respect of cases where we have challenged office memorandum so and so.
my submission is, Lordship, because Lordship, DLC recommended, after the DLC recommended, it goes to the SLC, Lordship.
What
Here
is the- what
SLC
is
is not
the-
considered, Lordship.
Rejection order is not there, my lord. How can my senior
DLC,
friend say
DLC recommended, Lordship. After that, is it placed before that the SLC, Lordship.
Not placed.
SLC not rejected, Lordship.
Not
They,
placed, my lord.
after that, Lordship, they approach before this and
Not placed before SLC with due respect.
he challenged the order dated 18/9/24, Lordship.
My lord, it is not placed before the SLC with due respect. What my senior friend has just submitted.
In a normal procedure, Lordship, DLC forwarded to the SLC, Lordship.
You read number 1. Slowly for your consumption. So first thing is the challenge to the office memorandum 18/9. This is 1.
Lordship,
All right.
Lordship.
Then, and this is pursuant to the notice dated 38. So 38 is this notice
Is the-
or the other notice.
No, Lordship, this notice, Lordship.
There is another notice on the same date where they were asked to submit all the representations, submit all papers.
Same date, Lordship, another notice is.
Same date, another
Yes.
notice was issued.
Yes,
So they will be considered.
Lordship.
They fall under this category. It will be considered in terms of para 4 of this SOP. Para 4 lays down the parameters,
Lordship.
immediacy, spent force. All these things are there. Yes. Well, we'll call up after some time. We'll go through it
Lordship.
after some time.
After some.
Yes.
I am deeply obliged.
14.
Orders of person material. Orders will be available.
Made to the law. Very limited scope, your lordship. I have approached this honorable court
the petitioner was issued a transfer order which is at Annexure 4, page 21. And the transfer order, if your lordship says, it was issued on 6/8/2020.
What is the violation here?
Lordship will kindly take up the transfer policy which is at page number 22.
22.
Starts from page 22.
Yes.
And 23, your lordship.
Uh,
One of the objective is to, as objective number 6, to ensure uniformity and transparency in transfers through a well-documented policy. And
no, which policy has been violated according to
lordship,
you?
page 24. Transfer timeline, there is a lordship will find. Transfer timeline. Transfer exercise may be completed within June every year based on the tenure completed by the officer's employees as on 31st of March of respective year. However, on exigency like resignation, superannuation, or demise, officer or employees may be transferred during the entire year. So there was a transfer timeline has been framed which says that by June, all the transfer exercise should be completed.
Where is your transfer order?
Lordship will get at page number 22.
20?
Lordship 21.
21.
So this, it was issued on 6/8/2025. I was transferred from manager, posted as an officer in Stephanguri branch, your lordship.
Is on the same rank?
Not same rank, I think. I don't, because earlier I was regional manager, now they are saying that is officer.
Then is it on the same rank or not?
No, the rank is same, my lord. He was never regional manager. He was posted as a branch head, branch manager.
So what is the this circular? It has to be completed within 31st March. Why?
No, no, these circulars are more or less in the nature of guidelines, my lord. In case an exigency arises.
Why do you issue a guideline if you have no intention to follow it?
These guidelines are in any case, my lord, they are line of decisions that they are not enforceable for writ of mandamus, my lord.
May not be, but they are enforceable against the bank for
For a minute,
consideration.
lordship will consider. Here is an officer who has imposed a major penalty. My lords, against him, there is a criminal case going on, my lords, for misappropriation of customers' money. My lords, he has been in this default for more than 1 year. It's not that he was transferred out within 1 month or 1 week, my lords. Now, the only reason appears to be
What is the tenure of transfer?
normally 3 years. But there is no hard and fast rule that we cannot transfer, my lord. Any organization, my lord, based on the exigencies of service, can transfer. My lordships are.
You are absolutely correct, but we want to know the reasons why he has been transferred.
Lord,
the order does not reflect anything.
Transfer orders normally do not.
But does it mean that
for that,
because you have the liberty, you can transfer anybody, shunt him out as and when you decide?
There is no question of shunting in out. It's a normal transfer. There is not a punitive transfer in any court. Nor is it his allegation that he has been transferred for a punitive reason.
Then you have to show why this.
Well, lordship will kindly have it after then 1 week. Within this week, I'll file my affidavit, because
you file it. But
because he has not joined the new posting, for more than 1 month.
He is on medical leave, your lordship.
He is on medical leave.
Yes. I'll file my affidavit by Friday, my lords.
Heard, learned counsel for the parties. Petitioner is aggrieved by the impugned transfer order dated 6/8/2025, whereby the petitioner, who was posted as manager in the regional office Tifu, was transferred and posted as an officer at the Serfanguri branch in the district of Kokrajhar. Stop. The grievance of the petitioner is aggrieved that the transfer policy, which is issued by the bank, by the Assam Gramin Vikas Bank, on 20th February 2025, provides for a transfer timeline, whereunder employees are to be transferred, or whereunder the transfers are to be completed within June every year, based on the tenure completed by officers and employees as on 31st of March of the respective year. So, counsel for the petitioner submits that this timeline has been flouted by the bank which is prescribed in their own guidelines. Stop. There is no reason furnished as to why the petitioner had to be transferred in the middle of the term. Whereas Mr. Ganguly, on the other end, appearing for the bank, strongly disputes the contention of the petitioner. He submits that these guidelines do not give any, do not confer any right on a petitioner to be posted at his place of choice. Stock transfers are because of administrative exigencies that apart. Petitioner, against the petitioner, there are several allegations and proceedings are underway.
No, they have been concluded and major penalty imposed on.
And the petitioner was proceeded with and major penalty was imposed in the past. So Mr. Ganguly, however, submits that he'd like to complete his instructions and file his affidavit within 1 week.
Well, I'll file by Thursday.
Coming Thursday.
This Thursday.
All right. Within 2 days, as he is posted with the required instructions. Accordingly, let this matter be listed again on
Next week.
when?
Monday next month.
Monday.
Monday.
22nd.
26.
22nd. Till the next date, till 22nd, if the petitioner has not been relieved of his present place of posting, the impugned order of transfer shall not be given effect to.
He's on medical leave.
What? Till 22nd.
May I please, Your Lordship? My Lord, this matter also, my Lord, similar to item number 13, my Lord, regarding compassionate appointment, my Lord. The petitioner of Your Lordship is an orphan, my Lord. His father died and even 3 months after the death of father, my Lord, mother of the petitioner also dies, my Lord. And therefore, my Lord, DLC Borpata, my Lord, forwarded, recommended his name, my Lord. Kindly see page 36, my Lord.
36.
36, my Lord, of my writ petition, my Lord. 24/10/11, my Lord. Now, my Lord, relevant page, my Lord, page 38, my Lord. Bittu Brahmo, my Lord. Then date of death, my Lord, detail is there. Reason for consideration, why DLC considered my case, my Lord. Applied within 3 months from the date of death. ASS pass, family pension and other retirement benefits not received because mother also dies, my Lord. Recommended for grade 3 post, requires a job for subsistence. Then, my Lord, after 4 years, my Lord, rejected.
This was issued on. This was issued on.
This was issued on. My this decision was 17/9/11. Then, my Lord,
2011.
yes, I'm coming, my Lord. Then what happened, my Lord? Then, my Lord, SLC rejected after 4 years, my Lord, though it was not communicated with me, and I came to know, my Lord, only through RTI, my Lord. Kindly see page 41, my Lord. Relevant page 47.
47.
47 relevant page, my Lord. Page 47, my Lord. I came to learn through RTI, my Lord. Bittu Brahmo, decision of SLC, the SLC considered the proposal and found that the application could not be considered due to want of vacancies.
2015.
For a period of 2 years from the date of making the application, and accordingly the application has spent its course, my Lord. Then, my Lord, DLC again recommended my name, my Lord. Kindly see, my Lord, page 52, my Lord.
8/12/2015.
Page 52, my Lord. 53 relevant, my Lord. 52 is the content of the letter, my Lord. 13/1/2016, my Lord. In the month of January, my Lord, 2016, my name again was forwarded and recommended, my Lord. Bittu Brahmo, 53, my Lord.
Yes.
Last, my Lord, recommended for the post of grade 3, minors in clause, maintained at Directorate of WPT and BC Department. So this was also, this has not been yet considered, my Lord. not placed before the SLC, or even if my lord placed but not communicated, I do not know, my lord. Then my lord, petitioner approached before this honorable court, my lord, and this honorable court, my lord, your lordship was pleased to pass an order, my lord. Kindly see page 59, my lord. 60, my lord. Order dated, my lord, 4/8/2023.
Yes.
It's 60, and then, my lord, relevant portion, my lord, 62, paragraph 7, my lord. Page 62, para 7. Considering the averments made in the writ petition and after hearing the learned counsel for the parties, this court is of the view that the writ petition can be disposed of with a direction to the state level committee SLC, which is shared by the chief secretary of the state, to dispose of any pending proposal relating to the petitioner, which is stated to have been forwarded by the DLC as far back as 31/2016. It is possible that SLC may have, in the meantime, already disposed of the proposal relating to the petitioner. In that event, a copy of such decision be furnished to the petitioner forthwith. In the event the proposal is found to be
After that,
pending,
what happened?
after, my lord, not known, it is not placed before the SLC, and SLC neither passed any reasoned order or rejected my guess, nothing is known.
This has to be placed before SLC. There is a specific direction.
Lordship, now we have in a new sense, Lordship.
This is prior.
Notification,
When
yes.
was it disposed of?
It's a 2023.
23.
So it is prior to your notification.
Yes, Lordship, prior to my notification. Lordship. But now, Lordship, the notice dated 30 August 2025, it is stated that anyone who challenged the OM, 24 OM, then he may place their name, Lordship, as per this notification, this notice.
Is it challenged?
I have challenged,
Yes,
now I have challenged.
now here in this petition, he challenged, and therefore his name may be.
Why don't you submit the particulars in terms?
Particulars I have submitted, my lord, but I could give only case number. Then, my lord, on Monday, case was numbered only, on Friday last. But I could not give the order, my lord. This is the copy, and I have taken the acknowledgement of the.
What order?
This, as per, my lord, notice dated 38/2025, particulars to be submitted by the aspirant candidates, my lord. That I have submitted
You
and
have
taken.
submitted.
I have submitted, but I couldn't find it since the matter is posted.
No,
first.
that is all right. You have submitted.
Submitted, I have.
Now
it is for the authorities to decide.
Yes,
Decide what?
yes.
Then
But
why have you
here-
filed a writ petition?
No, because
without pending,
because you have
Lordship,
inquired, my lord.
without pending, as per this notice, Lordship, without pending a case, without challenging the OM, Lordship, he may not submit his particular. So submission of that, therefore this case, Lordship.
No, but this case does not fall under that
Yes,
category.
yes, Lordship. And therefore, Lordship, the notice may go here in this case, Lordship.
No.
In the meantime, Lordship.
See, your executive order has placed
Yes.
two categories.
Yes.
Challenging 18.9 and not challenging 18.9.
18.9. Yes.
But here is a case where there was an order, the direction
The
was
order,
issued long back.
order is already been there, but Lordship, now 23. Now he is coming 25.
Whatever
Only
it
because
may
of
be.
this notice, Lordship.
No.
Only because of this notice, Lordship.
Whatever it may
And
be.
now, Lordship.
Once an order is passed by the court.
Yes, Lordship.
Ought to have been carried out.
Yes, Lordship.
If you want to reject him, reject it.
Then, Lordship, don't kindly fix the matter in the next week, Lordship. I will apprise before this court that whether this was considered or not. Without knowing the fact that whether this matter was considered or not.
You consider it, you get instructions.
Yes, Lordship, yes.
What direction you want now?
No, not placed, two placed. Two placed before the SLC, if not placed.
You have already submitted. You have already submitted.
I have
They will-
submitted.
Yes, already
they will-
submitted.
They will consider it.
His purpose served.
Office has given me to
His
understand
purpose
that
served.
so long as the standing notification, bad notification is there in force, my lord, my case will not be considered.
Then we'll issue notice here. We'll issue notice.
Lordship, your lordships made him fit, my lord.
We'll issue notice.
Yes, Lordship.
Otherwise, it is a deserving case, my lord. Mother also dies, my lord.
You had already submitted your details as per the notification 30 August.
But they sought for the, my lord, order. I could not give order.
It's
All right. Heard learned counsel for parties issue notice written about 4 weeks steps. Mr. J.K. Goswami, senior government, additional senior government.
Lordship, on behalf of Lordship.
Represents all.
No, Lordship, here in this case, Lordship, except I am on behalf of the
Number two,
5 lordship.
Num-
Yeah, 2 and 5 lords.
2 and 5.
Yes, lordship.
What about 4?
4. Oh yes, 4. 2, 4 and 5 lords.
2, 4 and 5.
Yes. My
Mr.
learned friend
Borpuzari
is for 3
number
and
3.
Ardhor lordship 1,
Mr. Ardhor for 1 and 6.
1 and 6.
But since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from the matter be listed after the returnable date.
Item 6.
Either it is considered or not considered.
Yes.
If it is not considered, your petition is pending, we'll see.
Some observations be there, then my lord, there may not be bar to consider.
Pendency of the writ petition shall not be a bar for the respondent authorities to consider the case of the petitioner in terms of the executive order dated 38. 30.
Yes, 38 to
300825.
lordship.
Subject to
30.
the petitioner submitting all required documents as per the notice dated
Dated
38.
10th, 30 08 2025.
Yes, all right.
You will oblige to.
16.
Yeah, your lordship.
Pension,
Lordship.
we'll issue notice here.
Yes, sir.
But council for parties issue notice. 4 weeks, Mr. D for menu, what case for? All.
Respondent number 1 to 4.
1 to 4, Mr. R. Borpuzari for respondent number 5.
5 minutes.
Since the respondents are represented by the council, notices are waived, extra copies be furnished within a period of 1 week from today.
Dear
Yes.
list.
17.
May I please, Your Lordship? Petitioner participated in the selection process of Central Armed Police Forces, my lord. But his candidacy has been rejected due to shortage in height. My lord.
Height.
Yes, my lord. Earlier recruitment, his height was 165, my lord. Now kindly see, my lord, rejection slip is 56.
We had passed a similar order in
There that in earlier matter, he have filed appeal.
appeal. Here
Here-
you have not filed appeal.
Not final.
File appeal.
My lord.
Let him file appeal.
Yes, lordship, but as per our guideline, lordship, appeal has to be filed on the same date.
That is not possible, my lord.
That and in this
Where is it provided? Page number
Page 34.
30,
34.
34.
About 1255.
No, it cannot, it may not be read to be a limitation. It may be read that they may prefer an appeal on the same day if they want.
yes. In similar matter, another order had already passed, lordship.
What is that
Yes,
order?
my lord. The same recruitment, my lord. This order is regarding present recruitment, my lord.
Hmm?
Present recruitment process, my lord. There are 12, 13 and 14.
No, this is, but there are orders passed where
Yes, that order.
appeals have been permitted to be filed.
Yes, that
Yes, yes, yes.
that order also there, my lord.
That all also. there.
Give us that order. This is under videography.
Yes, my lord.
Yes.
In that order, my lord,
petitioner was permitted to file appeal, my lord.
We are passing
Yes.
similar. orders.
Yes.
That would. That were reading. Central parties disclosed.
Obliged, my lord.
Yes.
Obliged.
Supplementary from motion item 57.
Maybe it's a lordship.
You are challenging their promotion.
Promotion order, lordship.
We should notice today.
Lordship, the only thing is this respondents, the private respondents, out of them, 2 have joined. And they are admittedly my juniors because I have NXC gradation.
How many posts are there?
Lordship, 6 posts. And out of the 2 have joined, 4 as per my instructions are yet to join. Lordship, respondent number.
You are challenging their promotion.
Promotion, lordship.
So we should notice it.
Lordship, but status quo isn't.
Status quo, how does it benefit you? Unless there's a decision by the court
Lordship,
that you have been wrongly overlooked.
Lordship, because.
We'll make the observation that it will be subject to outcome to the judge. Heard? Then it comes to the petitioners. Petitioner in the present proceedings have assigned the promotions made to private respondents 4, 5, 6, 7, 8, 9 to the post of draftsman.
Draftsman grade 2.
Draftsman grade 2 / planning draftsman grade 2. Office of the Director, Town and Country Planning. So, petitioner, you are presently serving as?
I am presently serving as storekeeper.
The petitioner is presently serving as storekeeper. And he claims that he fulfills all the criteria for promotion to the next higher post as per the service rules.
Service order, Lord.
Service order, stop. Since the claim of the petitioner has been overlooked and the private respondents have been promoted, petitioner is agreed and it has filed the present petition challenging their further promotion. That I should notice. Returnable 4 weeks, Mr.
I appear for respondent 1.
S. Bora appears for respondent 1.
2 and 3 I am appearing.
Mr. J.K. Goswami, additional senior government advocate, represent respondents 2 and 3. As such, notices on behalf of respondent 1, 2, and 3 are waived. However, extra copies will be furnished within a period of 1 week from today. Steps on respondent numbers
4 to 9.
Yes, shall be undertaken by registered post as well as registered post 80 as well as usual course within 1 week from today. Respondents are permitted to file their counter affidavits, if any. The promotions given effect to the promotion, the promotion order issued in favor of respondent 4 to 9 shall, however, be subject to the outcome of the writ petition.
The steps we will take through the respondent number 2 to the directors.
Why?
Lordship, because
registered post.
Lordship, because few of them have joined, few have not joined. So to the director, if we are allowed to take.
Directors, they are working on their
Changing their appointment order. You have to find their address and take steps.
I would like to.
68.
May it present. The petitioner is a child development project officer. Malada, I take your lordship to page 21st. 20. Malada. That is on 8th January 2024. The second one, I am Shaneshwar Musari. I was transferred from Chirang to Baksha. Then, my lord, that is on 8th January 2024. Then at page 2022, my lord. Page 22. That is on 27 June 2025, within 1.5 years. Again, I was transferred from Baksha to Chirang. The last one, the fourth one. Again, I was transferred from Baksha to Chirang. Now, my lord, that was on June 2025. Then at page 33, my lord. After 2 months, on 19th August 2025,
serial number 13, I was again transferred from Chirang to Nalbari within 2.5 months. I filed a representation. My lord, I approached this court. Court said, dispose of the representation, till then status quo. Now, my lord, the impugn order comes at page 41. In the third column, they say that you are in the BTC area for 5 years. Since 2024, they are transferring me from in the BTC area. Now, what is the serious exigency and immediate exigency that within 2 months, this issue has come upon? On the third column, they say that only because you have spent more than 5 years in the BTC area, so you have been transferred.
No, when you last approached this court,
my lord,
you had
said
posted
that
where?
court that is at page 37.
Yes, you were posted at
I was posted at, my lord, Chirang, my lord. Chirang. Against this impugn order of, my lord, against the order at page 33, 19th August 2025, I was at Chirang. I was transferred to Nalbari within 2 months. I filed a representation, approached this court. Court said, dispose of the representation, taking all my consideration about, because my brain, I had a stroke, my brain was some clot was there. And ultimately, my lord, they say now it is 5 years.
Where is the order disposing the representation?
This is the order, page 41.
41.
And the third column say that you are in 5 years in BTC area. 2024, they are transferring me one place to another in BTC area. Now this issue has come over them that 5 years here in BTC area. Within 2 months, that can be the reason for transferring me?
Yes, Mr. Goswami.
Yes, Lordship, it is categorically stated, Lordship, in the order dated.
Where are you posted now?
My lord, Nalbari.
Nalbari.
Where is your residence?
My lord, within 2 years, I'll be retiring. 2 years, 3 months. I'm staying near Chirang, my lord. The place where I'm posted, my lord.
So what is your, why are you challenging this order?
Well, this frequent transfer, that cannot be the reason. My lord, in a immediate serious cause, there should be a reason, because and my lord, memorandum also says that one, my lord. That the frequent
Mr. Goswami, get your instructions here.
Yes, Lordship.
Heard counsel to parties. Petitioner is agreed by the impugn order of transfer dated 4th of September 2025, whereby the petitioner was transferred from Chirang to Nalbari. ICD project. Petitioner suffers from numerous ailments and is undergoing treatment, and therefore he submits that he is required to be posted at a place near his residence, and in any event of the matter, he is superannuating in within 2 years. After 2 years.
Within 2 years, 3 months, I'll be retiring.
The superannuating within 2 years, 3 months. Stop. That apart, the petitioner has counsel for petitioner submits that he was transferred around for the past 5 years in the BTC area. However, in the impugn transfer order, the ground of his transfer has been shown that he has completed more than 5 years under one autonomous council, which is the BTC area. Stop. These transfers were not transfers at his own request, but were transfer orders issued by the department and the exigencies of service. Stop. Be that as it may, the ground for transfer that he had completed more than 5 years in the BTC area cannot be attributed to the petitioner, as these orders were issued by the department, notwithstanding the serious health ailments that he suffers. So, here are Mr. J.K. Goswami, additional senior admin.
For one.
APS for respondent number 1.
One.
Mr. P. Hazarika for
Respondent number 3 and 4.
appears for respondents number 3 and 4. Who is for
Lordship,
5?
two, I am 1 and 2, Lordship.
Who is for 5?
5.
District
Al-
Commission.
Also 5, Lordship.
1,
1, 2 and 5, Lordship.
And Mr. P. Hazarika for 3 and 4. Stop. When was the impugned order passed?
My lord, that
4th
is at
September.
1.
So incumbent has joined.
no, my lord, he has not joined. My lord, not it was transferred in my lord 19th August 2025. And there was a status quo order from this court, and this 4th September, the last impugned order. comes.
Where is the mention of the incumbent?
My lord, that is at page 33, serial number 13. And my lord, I was transferred with 18. Private respondent number 6. I have made a statement that he has not joined now. Paragraph 19 now.
Having heard counsel for parties, it is seen that the writ petitioner had earlier approached this court by filing the PQC number
4959
of 2025, where putting to challenge the transfer order dated common transfer order dated 19 August 2025, wherein the petitioner's name also figured. So this court by order dated
29/8.
2025 disposed of the writ petition directing the respondent 1 to take a decision on the representation filed by the petitioner. Stop. And interim protection till such decision was taken by the authorities, was issued by the court. Pursuant thereto, the impugned order dated so and so was issued or was passed by the respondents, whereby the representations to disposed of / rejected, and the petitioner was directed to join in his place of posting in Nalbari. But they say it is close to Nalbari Hospital.
Yes,
My lord,
yes.
because my hometown is in Kokrajhar, I've been treated over there, my lord. And now within 2 months, what is the necessity?
Lordship,
2 months, my lord, June to August.
Respondents will complete their instructions in the matter and pass we file necessary affidavits. Let this matter be listed on 17th October.
17th October.
Till the next date fixed, impugned order dated 4th of September shall not be given effect to.
So one thing, if we call for the entire instruction, the little instruction, Lordship, here in this case, one short instruction. Next week, Lordship, any date, Lordship, and on that day,
What short instructions will you get? You get your instructions, complete instructions.
Lordship, but the order dated 4th September 2025 is inclusive here in this case.
So
5 years.
Hear it on 17th October.
My lord, if my lord, page 33, that was the impugned order, because this representation was disposed of on 4th September. My lord, and that the impugned order may not be given effect to, my lord.
Which impugned?
That the impugned order by which I was transferred from Chirang to Nalbari, and it was disposed of by this 41 order.
Impugned order
19th August 2025, my lord.
Impugned order 19th August
2025.
2025, insofar as the writ petitioner is concerned, shall not be given effect to, along with the order dated
4th September 2025.
4th September 2025. in the
Problem.
next week fixed.
Problem.
David is for others, I think 18.
Yes, 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 yes.
This is the instruction.
What is the instruction? This is in respect of the writ petitioner.
Lordship.
In respect of the writ petitioner.
Lordship.
Who's the counsel for the writ petitioner?
I think R.K. Majumdar.
PK. None appears for the petitioner on called on the earlier occasion, that is 8/9/2025. The counsel representing the ASTC was permitted to complete her instructions in respect of the payments required to be made to the writ petitioner. Stop. The learned counsel has placed before the court that out of the total sanction amount of 18,05,147, total amount of 7,66,743 has been released, and the balance outstanding is 10,38,404. When do you propose to release it?
So it will take time, Lordship.
Why? We had passed an earlier order regarding the claims. Do you have a copy of that order?
No, Lordship.
Considering the issues involved, this court proposes to refer this matter for mediation. List this matter again before the mediation on 26th September.
Yes, 20.
Right.
Then, anyone for respondent 7?
I'm appearing for respondent 1.
1. Any instructions here?
Lordship, the respondent number 3 in the writ petition, the Director of Health Services has been asked to submit a proposal by the respondent number 1 on 6th of August, Lordship. We have not received the up-to-date instruction as yet.
Mr. Cholia, you are appearing for?
Lordship, I'm appearing for respondent number 2. Yes.
Who's for 3?
He, Lordship, I think.
Is also Health Department?
Yes.
Under I was late, report number 16, Malaram Police.
Oh.
My lord, as per direction of this lot on Agul Court, my lord, I have already filed the amended the post title, my lord.
Notice issued on respondent 7.
That direction was not given by my lord, but already my lord, my lord and my Mr. Solia has appeared, my lord.
You are appearing for respondent 7.
Yes.
No, Lordship, not for 7, Lordship. I am appearing, Lordship, in our position, there are only 3.
Respondent number 4, man.
There, and then there were 4. One was completed, Lordship.
7, only 4, my lord.
Where is the amended post title?
I have submitted before the section, my lord.
How many respondents are there?
Lordship.
4, my lord.
4 now, Lordship.
Now 4, my lord. Last occasion, my lord, the new incumbent has been implemented by this honorable court, my lord. That is last order, Lordship, kindly.
Next.
Pursuant to the earlier order, dated so and so, amended course title has been filed. issue notice on respondent number 4, the newly impleted respondent. Steps by registered post ID as well as union force within 1 week from today. Have to be listed after the returnable date. Yes.
Wait, please, your lordship. My lord, there were 3 petitioners. Separate writ petitions. All were closed by your lordship's order. My lord, the others, they got the relief. And there was some communication gap, my lord. So my writ petition also, I mean, since I was petitioner number 2 in one of the case, therefore our case was also closed. My only limited prayer is, my lord, lordship will recall the order only to the extent of the present review petitioner, because my cause of action is still alive, my lord.
Where is the order disposing of?
Yes. 65. Page number 65. Seven 9/23. It is submitted by Mr. N. Deka, Learned Counsel for the petitioners, have informed that they have no longer interested in pursuing the matter anymore. Sri Nayak, Learned Standing Counsel for respondent, also placed on record a copy of the letter written to the Deputy Secretary by petitioners in so-and-so, stating that he wants to withdraw his case as he has no grievance against the department. In that view of the matter, its petition are closed. My lord, in fact, in this petition, I was petitioner number 2. Mr. 1, my lord, because he got the promotion, therefore he expressed his, willingness not to pursue the matter. Only for the ends of justice, my lord, I am not
Who
trying
were
to-
the petitioners? One is
One-
Nirmal Kumar,
Yes, and second is
Akhtar Ali.
Pulin Meri. One Nirmal Kumar, one my lord, Akhtar Ali and another, that is Akhtar Ali and another is the petitioner. And in the third case,
Pulin Meri.
it was Pulin Meri. In the second case, my lord, 5/20 of 2012, I was the second petitioner. Akhtar Ali, which one was it?
So petitioners in 520,
Yes,
they did not
no,
issue instructions,
no, my lord.
both
Was-
of them.
Both of them.
So it is only submission of the council.
True, my lord, true.
Then
No, we are not attributing any error on the part of the court, my lord, just for the ends of justice, my lord, since my cause of Akhtar Ali has also retired, therefore he doesn't have any grievance. But I am still, my lord, in service and my cause of action is still alive. It is in that context, my lord.
no, after Akhtar Ali has also got his promotion.
No, Akhtar Ali retired, na? Retired.
No, para 4 of your review petition.
No, I'm sorry, my lord.
Para 4 of the review petition.
Yes, yes.
He's got his promotion.
Promotion. I'm sorry, my lord.
So only who is the person?
I am Biswadev Goswami.
Heard. Sir, anyone for the respondent? Any objection?
There is no private respondent. No.
There is no.
Only state is the official respondent.
Any, it appears that there was some communication gap between council and the clients. But Mr. K.N. Chaudhary, Senior Counsel, assisted by Mr. N. Deka. For the review petitioners, Mr. R. Dhor, Standing Counsel, PWD. Only PWD is there.
Yes, yes.
This review petition is directed against the order dated 7/9/2023, passed in WPC 532 of 2012, WPC 520 of 2012, and WPC 521 of 2012. all these writ petitions came to be disposed of by the order dated 7/9/2023, recording the submission of the council on record that the writ petitioners were no longer interested in pursuing the matters. So the writ petitioners were therefore closed and interim orders were vacated. Stop. Subsequently, this review petition has been filed. That because of communication gap, the submission made by the council on record was in effect in respect of Sri Nirmal Kaur, petitioner in WPC 532 of 2012, Sri Akhtar Ali, writ petitioner, one of the writ petitioners in WPC 520 of 2012, and Sri Pulin Meri, the writ petitioner in WPC 521 of 2012. All these petitioners before the court had in the meantime been promoted to the post of what post?
Assistant Executive Engineer.
Assistant Executive Engineer. So, and
And
therefore
Milord
they were
Pulin Medi has retired.
they have not no, all these were promoted or Pulin Meri retired before promotion?
Pulin Medi retired.
Before promotion. So when you write these writ petitioners in WPC 532 and writ petitioner Sri Akhtar Ali in WPC 520 of 2012 were promoted to the post of Assistant Executive Engineer.
Yes.
Whereas Sri Pulin Meri, petitioner in WPC 521 of 2012, had since retired in the meantime. Stop. However, Sri Biswadev Goswami, who was petitioner number 2 in WPC 520 of 2012, his claims, in so far as he is concerned, his claims made in this writ petition are still alive, as he is still in service. He is still in service.
Yes, yes, ma'am.
And his case has not been considered for promotion to the next higher post. So it is submitted by the Learned Senior Council that since the writ petitions, since the instructions to the advocate on record was forthcoming, primarily from one of the writ petitioners.
Nirmal.
Huh?
That is Nirmal Kaur.
Namely Sri Nirmal Kaur. And he came to be informed that the writ petitioners are not interested in pursuing the writ petition. They say submission came to be made before the court, and on the basis of which the order dated 7/9/2023 came to be passed, closing all the writ petitions. Stop. Subsequently, the council was informed that the present review petitioner, namely Biswadev Goswami, has not given up his challenge made in his writ petition, being WPC number 520
of 2012.
0 of 2012. And therefore, this order be recalled in respect of Sri Biswadev Goswami, writ petitioner number 2 in WPC number 520 of 2012. Counsel for the respondent, Mr. R. Hall, hearing for the PWD department, does not object to the prayer made. Para considering the submissions made before this court and upon perusal of the averments made in the review petition, this court recalls the order dated 7/9/2023 passed in respect of WPC 520 of 2012. Stop. The said petition shall now be listed for hearing before the court, shall be restored to file and be listed for hearing before this court. It is made clear that the writ petition, in the said writ petition, the said writ petition is only the claims in respect of writ petitioner number 2, this Sodev Goswami, can be considered, shall be considered at the time of hearing.
Yes.
So, the order dated 7/9/2023, passed in WPC number so and so, so and so, so and so, therefore stands modified to the extent passed in the review petition today. Stop. The said order dated 7/9/2023, passed in WPC so and so, shall be read together along with the order passed today in review petition number 5 of 2025. Copy of this order be brought to the notice of the Registrar Judicial. Keep disposal.
Item 22.
In this matter, the case of the petitioner has been reconsidered and has been rejected, Your Lordship. The minutes of the meeting of the SLC, I'm placing before Your Lordship.
Reconsidered.
Reconsidered, Your Lordship, and been rejected.
Where is the direction of the court?
Let's say page 10, Lordship. 11, page number 10, Lordship.
6/3.
Yes.
6/3/2024.
6/3/24, 9
Third,
10.
counsel for parties, this contempt petition was filed alleging willful disobedience of the directions contained in the order dated 6/3/2024, passed in 1982 of 2023. By the said order, the coordinate bench directed, the coordinate bench remanded the matter to the SLC to reconsider the case of the petitioner by applying Clause 15 of the Office Memorandum dated 1/6/2015 in its next immediate sitting and pass appropriate orders. Para. Learned counsel representing the respondents, Mr. R.R. Gogoi, has placed before the court the minutes of the SLC meeting held on 6/6/2025, whereby the case of the petitioner came to be considered by the SLC, and after a threadbare discussion, the claim of the petitioner for compassionate appointment was rejected on the ground of efflux of time, as the condition of immediacy was no longer existent pursuant to the death of his father.
Yes, sir.
The death of the father of the petitioner. And the proposal for compassionate appointment of the writ petitioner of the petitioner before the court in the contempt petition, therefore stood rejected. So, copy of the said order has been placed before the court today by the counsel appearing for the respondents. In that view of the matter, taking into consideration that the directions contained in the order dated so and so, passed in WPC so and so, have been carried out, and the order dated 6/6/2025 has been passed by the SLC. The contempt petition stands closed, notice is issued, stand recalled. Copy of the order is placed in the case record. Copy of the order passed by SLC is placed on record. Yes.
Item 23.
May I please, Your Lordship, as Mr. Roy is out of station, let this matter come up, as Mr. Roy is out of station, let this matter come up again on 22nd.
We are issuing notice here, but counsel for parties issue notice in a general 4 weeks. Counsel for the review petitioner will ensure service of copies on will take steps on the respondent by registered post AD within 1 week from today. List accordingly.
24.
Maybe Mr. Lordship, so kindly given timing, my lord. The English counsel who is elects the another statement.
Notices, await service report,
I am not aware of this case, my lord.
huh?
Not aware of this case, my lord.
Not aware. Let this matter be listed after 2 weeks. And the registry to make necessary endorsements regarding service of notice on the respondents.
Obliged.
Supplementary list for orders items 59 to 67.
Wait, people listen to that program. No, it will time like you. We'll call up one matter before this. Just one matter.
Pending item 13.
Yes.
This matter may be passed over for the time being. The conducting counsel, Mr. P. Sharma, is in court number 9, Lordship.
was his urgency to do the matter. Yes. Lordship, on what ground, Lordship, they had challenged the 18 OM dated 18/9/24, Lordship. That was not rejected by the SLC, but the DLC, Lordship. DLC recommended, Lordship. On what ground he has come to the court, Lordship? The court of action has not arisen,
He
Lordship.
wanted you to tell us under what criteria is it Roman?
Lordship, I have
Roman
received
II?
in the judgment, Lordship, Ochutondon Das,
No,
Lordship.
no, not that. Just tell us from your executive order, his case falls under Roman I or Roman II?
Roman I, Lordship.
Roman I.
Roman I, Lordship.
Therefore, he
but
says
Lordship, in the Ochutondon Das case, Lordship, is not applicable, Lordship.
whether it is applicable,
Not applicable,
if it is covered by Roman I, then let it be considered.
Lordship,
Then
kindly see
appropriate
the,
orders be passed.
Lordship, kindly see the para 7, Lordship, Roman 6, Lordship. She has received the pension, Lordship. His mother received the pension, Lordship.
Pension?
Lordship. Para 15, Lordship, is clearly stated.
Para?
15.
1-5.
1-5, Lordship.
There is no 1-5, Ochutondon. You are referring to Ochutondon?
Lordship.
Ochutondon?
Ochutondon, Lordship.
Para?
Para 7, Roman 6, Lordship.
Roman 6.
Roman 6, Lordship. To decide the questions of financial status, Lordship. Got, Lordship. In Annexure 3, Lordship, she has received the pension, Lordship. Means his mother has received the pension.
All right, let him come. We'll decide. At 2 p.m.
Items 59 to 67.
Yes.
Well, yeah, the main question we have filed an IA, my lord. We have also filed an IA, but that will not come because here, my lord, the main question is this, my lord, when a committee has been constituted, who has constituted a committee? If you also see in item number, my lord, 60, 3476, next, group 9, 165. This in 165, 1665 filed an IA. And that little committee of the also like. My lord, as per the Mission Shakti guidelines, no even state level committee has been formed, my lord. What can take place? Seven committee of it. That's right. My lord, may take up 3476, my lord. The next case. There you also find, my lord, the 3476, next case, my lord. Second one. My lord, at page 53, my lord, you'll also find.
Yes.
State level committee.
No, what is this? This is a part of?
This is also, my lord, this is because against the Prime Minister notice, my lord, we have approached this number board.
No, you're referring to page 56. What
53, 53.
53, all right. It is a part of what? Some
The part of the Mission Shakti, I'm sorry,
Mission Shakti.
Mission Shakti guidelines, yes.
Mission Shakti guidelines.
Well, that starts, my lord, at page 30, my lord.
All right.
Page 30. That was issued by the central government. And there were two level committee are there, my lord. That one is, my lord, 53, state level. The overall implementation of the scheme at state UT level will be done by the committee headed by the Chief Secretary. The committee will be serviced by the Department of Women and Child Development, Social Welfare Department of the concerned state UT. The other members of the committee would be nominated by the Chief Secretary, drawing officers from the 11 departments like Education, Health, Police, Skill Development, Banks, FI, etc. on the same line as the National Level Committee. The committee shall meet.
No, you tell us in a nutshell what happened
Yes,
here.
now, my lord, here, part when central level committee has been, my lord, shown here in the Mission guidelines.
You are employees of what?
We are the employees, my lord, originally it was a, my lord, fund organization. Now we have been taken over by the, my lord, this sick level. Now we have been paid salary, my lord. Now they say that no, we are not the employees, my lord. My lord, we have been taken over, my lord, now. From the prior.
Where is the order or MOU or anything of?
No MOU, my lord, but salary sheets are there. They are paying salary, my lord. If you also see, my lord.
Yeah, you are agreed by which order?
We are agreed by, my lord, the termination order, my lord.
Where is that order?
Yes. An earlier advertisement order in the other case. My lord, here the appointment is at page 89, my lord.
89.
89. My lord, this is issued by the additional deputy commissioner, my lord. There is nothing, my lord, that they have taken this one, my lord.
Is there any appointment order given to you at the time?
No, appointment orders were originally, my lord, given to us, my lord, by the Northeast Voluntary Association of Rural Development. Then,
Now,
my lord, they are
they're what? They're closing the center or?
no, they are not closing the center, my lord. Their agreement was expired. Thereafter, my lord, all the employees were taken over by the.
No, but how? On what basis are you saying that you are taken over?
Well, taken over because they are paying salary or salary. Missions, as per the Mission Shakti guideline, they were taken over. Well, the Mission Shakti guideline has been issued.
Where is that provision that is to be taken over?
I'm Is, my lord, if you also see the director's letter, my lord, at page 63.
$63.
Director Women and Development. Like a handing and taking over of one-stop cell equipment and recruitment of staff thereof. With reference to subject above, I would like to inform you that the government of India has launched Mission Shakti as integrated women empowerment program, an umbrella scheme for the safety, security, and empowerment of the women for implementation during the 15th Finance Commission so and so. As per the earlier communication letter so and so, you are requested to review the performance of the implementing agency and proceed to take over the charges of one-stop center if your district on completion of the terms of the agreement. In this regard, it seems that the process of handing over and taking over the charge of OSC from the implementing agency are not yet completed by many districts. It is very essential to maintain uniformity in the service delivery and management of the OSC throughout the state. Therefore, the concerned district social welfare officer are directed to complete the process of taking over the charge. Well, the direction is given to the district social welfare officer, charge OSC within 31st March 24 as it where is basis. So as it where is basis, my lord. You may issue notice to the implementing agency regarding handing over and taking over the charge.
You are working as what? You're employed as?
Different, my lord, all post, my lord, we are working. All post, different, my lord, capacity, different capacity, my lord. So, as is
So
very
you are an existing staff.
existing staff, my lord, we are temporary, my lord, and they are again advertisement will be issued for appointment of temporary employees, my lord. So my question is this, my lord, why temporary employees, my lord, should be replaced by another temporary employees? We could have continued, my lord. Last time, my lord, your losses order.
This particular communication at page 64.
Yes.
There is a clause in G.
Yes.
That existing staff will be continued till completion.
My lord.
So it conceives of floating in advertisement and inviting applications.
My lord, selection of the employee of the Maruti so-and-so guards should be completed within 31st March. The selection committee has already been constituted and sent to your office so-and-so, so-and-so. So, my lord, they have sent, my lord, one advertisement by the director and that was cancelled. Next page. Next page, your lawsuits may see, my lord. That is at page 4th of March 25. Page 65.
That was cancelled.
That was cancelled, my lord. Yes, that your lawsuit fine, my lord, at page 73. Kept in abeyance, sorry. Sorry, kept in abeyance, not cancelled. It is kept in abeyance.
Then?
That, page 73, your lawsuit may see, my lord. This was the advertisement issued by the director.
Right, then?
Then, my lord, this advertisement was issued by the additional deputy commissioner, my lord.
Subsequent another.
Yes, another, my lord.
Where is it?
That is kept in abeyance. That is still there, my lord. That is kept in abeyance only. That doesn't have find it.
No, that.
Page 73. No, 73 to abeyance. Page 82, my lord, if you are lost to see.
This is a new advertisement.
New advertisement by the district commissioner, my lord. And my lord, my submission is this, my lord. This has been issued here, no reference of any committee, my lord. And, district level committee has been not been referred to here, my lord. They have issued that district commissioner has issued this advertisement. Whereas, my lord, this advertisement issued by the director is still there, only it is kept in abeyance.
No, you are referring to district level committee.
District level committee has not been formed, my lord. No, nothing has been said, my lord, who has formed the committee and who are the members. My lord, now in the IA, my lord, they have annexed a meeting of the district level committee or LSD. But if your lordship will see that in the IA, well, it is peculiar. IA in the read first read my lord. 1665. That is peculiar, my lord. I do not understand, my lord. If your losses take up the IA, my lord, in the 1665.
Yes.
Well, they are at page 18, my lord. They have annexed a meeting, my lord.
District level committee.
Yes, they say. Who has formed the committee, my lord?
Huh?
Who has formed the committee? Nothing is there, my lord. State level committee has not been formed till now. And if your lordship will see the signatures, my lord, in the at page 21, well, some other persons have there. Only 5, my lord, typed out. Then others are there, my lord, they have written their name. And whether one person is absent. Absolutely irregular, my lord. I don't know, my lord, whether this is the executed or the original, my lord. And in the earlier affidavit opposition also there is no mention about the committee, my lord, meeting. You know, reply you have annexed that affidavit, my lord, if you are lost time. If your losses.
This IA is filed by the state.
State, my lord, yes.
IA number 2241.
Yes. I know.
2241.
2241, it is filed by the district commissioner. And district social worker. And if your lordship will see, my lord, the affidavit in this case, my lord, filed by us, there I have annexed the earlier affidavit, my lord. There is no reference of any committee. At page 68, my lord. The affidavit starts at, my lord, page 55. And at page 68, my lord, the affidavit is there. Document. There is no reference of any committee. Let them produce a record who has formed the committee, who are the members, and when they have taken a decision to replace us. At one place, my lord, once they have produced a report, my lord, the losses passed the order that they found they cannot issue the so-called notice also if any difficulty is there. Well, why not? They are paying the salary, my lord, naturally they can issue notice if anybody calls anything. That page 68, my lord, affidavit.
We will come back at 2. At 2.
Lordship.
Much. Come back at 2. Before you begin,
yes,
I was thinking this will take some time.
Yes, sir.
We can have it at the end of the list.
Lordship.
We'll
Lord.
call it up at the end of the list.
Lord.
Let us complete the other matter.
Lordship.
Well, I think my lieutenant can produce a report of the committee.
No, Lordship, I have to submit. It is not that this is a
We'll
one-way traffic on.
We'll hear you at the end of the list.
Yes, Lordship.
Timing, I think 13.
My apologies, my lord.
No. No, Mr. Chakraborty, what we want to know is we are not issuing any directions to for any positive order
Lordship.
or for any negative order.
Lordship.
We are only saying that in terms of your executive instructions, it appears that they fall under category 1. And therefore it will be placed before SLC. SLC will consider and pass appropriate order.
As per the law, Lordship.
As per law.
Lordship.
Yes?
Yes, ma'am.
Heard counsel for parties, this application has been filed by the petitioner. He is seeking appointment on compassionate ground. As his late father, who was an employee under the irrigation department, posted at now Boisa Lakhimpur as a tractor driver, died in harness on 21/3/2006. So petitioner submitted his application for appointment on compassionate ground on 5/6/21. And the same not being considered by the DLC, he had approached his court by filing WPC 8092 of 2022. This court, by order dated 6/1/2023, disposed of the writ petition directing the application of the petitioner be considered and placed and considered before the next available DLC of the district of Lakhimpur. So, in compliance, in deference to the said order passed by the court, the DLC in its meeting held on 7/7/23 recommended the petitioner for appointment on compassionate ground on a grade 4 post under the Office of the Inspector of Schools, LDC Lakhimpur. Stop. However, his case was not placed and or considered by the SLC. Stop. Thereafter, it is the apprehension expressed by the petitioner that in view of the office memorandum dated ABP 104/2024/90 dated 18/9/2024, the case of the petitioner has not been considered by the SLC. Stop. Being agreed, he has filed this writ petition putting a challenge to the same OM dated 18/9/2024. Stop. Learned counsel for the petitioner also submits that the case of the petitioner cannot be rejected on the basis of the OM dated 18/9/24, as there was already a recommendation in his favor by the concerned DLC well prior to the office memorandum dated 18/9/2024. Stop. This recommendation in favor of the writ petitioner was made pursuant to the directions issued by the court by the order dated so-and-so in WPC number so-and-so. As such, the non-consideration of the case of the writ petitioner by the SLC on the ground that the same is barred under the OM dated 18/9/2024 cannot be, is contrary to the provisions of law as well as the directions issued by the court. So, Mr. A. Chakraborty, learned government advocate representing the respondents as well as MSD Neowit representing the irrigation department, submit that pursuant to orders passed by the court after issuance of the OM dated 18/9/24, executive order dated 30/08/2025 came to be issued, whereby the government laid down a standard operating procedure for disposal of matters of compassionate appointment. The cases, guidelines, and judgments and timeline for disposal are detailed in the said OM dated so and so. Stop. That apart, on the same day, that is 3008/2025, the government issued another order whereby the persons who, whereby particulars in respect of the person seeking compassionate appointment were permitted to be submitted to the appropriate level in the government, subject to fulfillment of the prescription mentioned in the said notice dated 30/08/2025. Stop. Learned government advocate disputes the submission made by the counsel to the petitioner. Stop. It is submitted that the OM dated 18/9/2024 was issued, taking into consideration the judgment of the apex court rendered in Devobrat Tiwari, State of West Bengal versus Devobrat Tiwari. So, under such circumstances, the government of Assam had issued the OM dated 18/9/2024. Stop. He therefore submits that the challenge made to the OM dated 18/9/2024 cannot be sustained as the same is issued in terms of the directions issued in Devobrat Tiwari by the apex court. Para. Be that as it may, taking into consideration the submissions made by the counsel for the parties and the averments made in the writ petition, it is seen that the writ petitioner's case was considered by the DLC in its meeting held on so and so date, recommending the petitioner for appointment in compassionate ground in a grade 4 post under the office of Inspector of Schools, Lakhimpur. Stop. The recommendation in what was the recommendation? Inspector of Schools?
Recommended for grade 4 under Office of the Inspector of Schools, LDC Lakhimpur.
LDC Lakhimpur. So this was required to be considered or placed before by the SLC, which however was not done. And while the matter was situated thus, the notification OM dated 18/9/2024 came to be issued. Stop. In order to remove the difficulties and streamline the process, the government has issued an executive order dated 30/08/2025, laying down the standard operating procedure for disposal of matters of compassionate appointment. There are two categories of cases as per the criteria prescribed. In the first category are cases where the office memorandum dated 18/9/2024 has been challenged. And in the second category, the cases where the office memorandum dated 18/9/2024 has not been challenged. Stop. From the averments made in the writ petition, it is seen that in the present proceedings, the challenge is made by the petitioner to the office memorandum dated 18/9/2024. Para. For convenience, the the criteria, the type of case as specified under Roman 1 is extracted below. From the perusal of the criteria above, it is clearly seen that this criteria includes cases where challenges have been made to the OM dated 18/9/2024. and which includes similar cases which have been disposed of by this court by referring to the order dated 3/4/2025, passed in WPC 342 of 2025, pursuant to notice dated 30/08/2025. Stop. All these cases shall be considered and disposed of by the concerned DLC/SLC on merit by taking into consideration the criteria specified in para 4 of the SOP and the guidelines and the judgments mentioned in column capital C and D of this clause. So, para. The executive order dated 30th August 2025 also clearly lays down the parameters of the criteria to be taken into consideration while disposing of the cases under compassionate appointment, which are specified in detail under clause 4. So, perusal of the executive order dated 30th of August 2025 makes it clear that writ petitions where challenge has been made to the OM dated 18/9/2024 and are to be considered and disposed of by the DLC SLC on their own merit by taking into consideration the criteria specified in para 4 of the said OM dated so and so. Stop. Under such circumstances, this court is of the view that the writ petition can be disposed of, directing the respondent authorities to take into consideration the claims of the writ petitioner and dispose the same by passing a speaking order as prescribed under clause Roman 1 of the executive order dated 30th August 2025 and by taking into consideration the parameters specified under clause 4. Stop. This order, however, is subject to the particulars required to be filed by the petitioner in terms of the order. Notice dated 30/08/2025 issued by the Personnel Department, Government of Assam. Stop. It is informed to the court that today is the last date for submission/uploading these particulars in terms of the notice dated 30/08/2025. Stop. The writ petitioner, writ petitioner therefore shall be permitted to submit his particulars in terms of the notice dated 30/08/2025, whereupon if the particulars are found to be in order, the case of the petitioners shall be considered along with other similarly situated matters and pass appropriate orders in terms of the office member of executive order dated 30 August 2025. Writ petition accordingly stands closed in terms of the above.
Deeply obliged, comrade.
It will order to Lady Vakunkal. The last data. It has to be uploaded.
Supplementary list for orders, item 68.
Yeah, please, Your Lordship. Service in respect of respondent number 4 is awaited.
As per office note dated 11/9, service report on respondent 4 is awaited. Matter be listed after 3 weeks.
What should kindly allow the interim to continue?
interim order passed earlier will continue. Matter to be listed immediately, matter to be listed on 15th October.
Obliged.
69.
Yeah, please, Lord. As far office note, my lord, 10-9, my lord. And the matter may be placed before Lozima, my lord, for service of notice upon the respondent number 8, my lord.
In terms of the office note dated 10/9/2025. As per office note dated 10/9/2025, AD card or unserved notice has not been received by the substantive date. But it was already placed before Lozima. Has Lozima passed any order?
No, my lord, not placed, my lord.
Therefore, the matter be placed before the Lozima court for necessary orders. Yes.
Daily list for admission, item 25.
Yes, your lordship. Lordship, I have get the instruction in this regard, lordship. It's a very 2 lines brief instruction from the department that already other pensionary benefits has already been released. Only for the suspension period, file has been endorsed to the personnel department as it is for 8 years duration, and till date waiting for their response from the personnel department. Lordship, may kindly give, that is the report from today only, lordship.
Yes.
Yes, my lordship, give a short date, my lordship.
MSR Begum for the petitioner,
MM Kotoki.
MM Kotoki. Standing Council, Veterinary,
Animal husbandry and veterinary.
Animal Husbandry. Raise for further time to complete the instructions. List again after 3 weeks.
Obliged, lordship.
26.
Lordship, in the earlier order, Lordship, your Lordship directed us that to submit the status of the appeal, Lordship. Yes, Lordship. Lordship, that was not received, Lordship. Can you fix the matter in the next week, Lordship? I will apprise, Lordship.
Look, it's a dismissal from service.
Yes.
Well, 2 grounds, perversity, 1.
No appeal. What is the status of the appeal?
My lord, appeal, your lordship will kindly see the second order of this honorable court, my lord. This because this honorable court, my lord, held that the appeal need not, they should not proceed with the consideration of appeal. The writ petition will be heard on merits, my lord. Because I am in a very narrow campus, my lord. Exactly identical allegations.
No, this is a, you are waiving your right.
Yes.
There's no direction from the court as such. You have waived your right.
Yes,
But
that's correct.
you have preferred the appeal.
Sorry, my lord.
You have preferred the appeal.
Yes, appeal has been preferred, but the problem is that, my lord, there is a clear-cut discrimination in imposing the penalty.
Mr. Das, you are
Yes.
well aware.
Yes.
It is a statutory remedy. You have
Availed it.
You have preferred an appeal. We
Yes.
just want to know what is the status.
Yes.
If they don't pass an order, we will decide on this matter.
Not only humble prayer is that, my lord, let them file the affidavit, my lord. He is retiring, he is going to attain his age of
Yes,
superannuation. my
Lordship,
lord.
I will file. I will file in the
No.
next week, Lordship.
This is the case of dismissal.
Yes.
Dismissal
Yes.
from service, my lord.
So what affidavit is required? We have to see, you are challenging the manner in which the inquiry is being
Only
conducted.
2 grounds, perversity, relevant evidence not considered. Second is discrimination, because similar allegations were leveled against 3 persons. My lord, another authority imposed lesser punishment and a different authority imposed upon the petitioner punishment for dismissal from service. In a very narrow campus. That's why, my lord, I insisted that this matter may be taken up for, even if they don't, even if they produce the records also, that will suffice the purpose. my lord.
Yes, I will.
Yes, what do you want to do?
Lordship, first, Lordship, status of the, as per the direction, Lordship, in the earlier direction, earlier order, Lordship, in this case, It is for the status, directed to, that to apprise the status, Lordship.
What is the punishment imposed in respect of the others?
Minor punishment, my lord. In withholding of increment, one increment, two increment, that's like, my lord. I have already annexed those penalty orders.
So kindly fix the matter in the next week, Lordship.
In those matters, superintendent of police impose the penalty. It's a minor penalty. Here, my lord, DIG impose penalty, dismissal from service. Otherwise, allegations are exactly same. And the incident basing on which the allegations were leveled was also same, my lord.
But separate disciplinary authority.
Separate disciplinary in penalty order, my lord. I am basically on quantum of penalty, my lord. Even if they pass minor penalty, my lord, then also, my lord, I'll be able to serve. Because after dismissal, I'll not get anything, my lord.
You get your instructions and file your affidavit or get your record.
Yes, Lordship.
What do you want to do? Make up your mind.
Lordship, I will file my affidavit and call for the record, Lordship, and I will apprise before this honorable
When do you
regarding the
intend to do that?
next week, Lordship.
Next
I will.
week?
Yes, Lordship.
Fine.
All right.
Maybe it's a last chance, my lord. With all due respect. Humble prayer.
Then Monday it will. better.
No issue.
Monday or
22nd.
yes, Lordship. 22nd, yes.
All right, list on 22nd, enabling the government advocates to complete his instructions with regard to
it may be
the
20
status of the appeal.
23, Lordship. 22nd, Lordship.
26th is the last working day.
No, 23. 23.
That's
Well,
right, but 26th is the
Tuesday.
last working day.
No, Tuesday, Lordship. Monday.
No, we know, but your
26th
job,
is the last.
our job begins when your job ends.
Lordship, 20. Then
So
22,
you have to
Lordship.
complete your
Yeah, all right,
arguments on
Lordship, 22.
23rd. Only then we can deliver an order.
22.
All right?
22.
22nd. Affidavit, if any, can also be filed by
Lordship.
the respondents. Mr. H.K. Das, counsel, appears for the writ petition.
Lordship will take the trouble to.
List on 22nd.
26. Lordship will take the trouble, if possible, disposal, my lord. Subject to.
Subject to the availability of it is also made clear that the relevant records pertaining to the disciplinary proceedings leading to the dismissal of the petitioner be also produced for perusal if required by the court.
Lord. Highly obliged, much obliged.
Item 27.
Application. My lord, petitioner before your lordship is a cancer patient, my lord, having cardiology problem also, my lord. Lordship, kindly have a look the order dated, my lord, 18/8, my lord. There was a direction given, my lord, to make a settlement for my pension, my lord, but till date has not been done. As a result, my lord, the petitioner could not go for further treatment, my lord.
Yes.
Yes, my lord, may see that instruction, my lord, that I have placed. Almost an amount of more than 85 lakhs has been released to the petitioner by virtue of arrear salaries and other components. Only thing is, my lord, the petitioner is getting provisional instead of.
It is in
final.
respect of the forest ranger, my lord. I am asking, my lord, SCF and DCF. They are saying, my lord, my ranger payment was given, my lord. They are twisting from this corner to that corner. What about my SCF and DCF? Along with other pensionary benefits. 85, my lord, my salary long back, my lord. Right from 88, they have given, my lord.
When did you receive this amount?
This is, my lord, when I was a ranger, my lord. That amount was paid to me during my ranger period, my lord.
When was it released?
This is all.
Well, it was released somewhere in May, my lord, of this year.
Huh?
Somewhere around May, my lord. We may see at the end that treasury bill is annexed, my lord, in this.
Here is my case is, my lord, SCF and DCF salary, my lord.
We'll examine that. Your opening statement before the court is you're a cancer patient. because
Yes, I'm
not
cancer
released,
patient,
you
my
have not
lord.
been-
I'm cancer patient, I got halt, my lord.
That's all right, but perhaps you do not have the instructions that this amount has been recently released to you.
Kun maur ki or salary level.
This is on 13/5/25. We are not undermining your difficulties, but
That is, my lord, area salary.
we will examine this matter. Your claim is with regard to pension.
My lord, pension and area salary of SCF, my lord.
Please
And
get your
this-
affidavits on record.
No affidavit has been filed.
One we had filed initially, my lord, when provisional pension was released. We will file
affidavit
another
here.
one.
There is no affidavit here.
One and more.
There is no affidavit.
This, I think, my lord, that instruction we have not brought on record. That we will
File
bring,
it
my-
within 1 week.
Yes.
Mr. J.I. Borbuya, counsel for the petitioner, and Mr. I. Botakur, standing counsel, Forest.
Forest.
The standing counsel submits that he has received instructions. And as per his instructions, his earlier area salary for during the post of in the
SCF
post
and
of
DCF, my lord.
ACF and DCF had been released.
Along with the regular pension.
So which amount has been released?
Arrear salaries
Arrears
as well
salaries
as
of
provisional
Ranger.
pension.
In which post?
Ranger post. It is right.
Sanction. Sanction.
That is, my lord, if your lordship permit me, I can give you one copy, my lord. That is, they paid, my lord, 2006 to 21. That way to one day. Now they are saying, my lord, we
No, no,
paid.
that is correct, but whether the amount has been released or not. The standing counsel submits that the certain amounts have been released to the petitioner. He further submits that he would like to bring all this on record by filing a proper affidavit. They are considering the claim of the petitioner, considering the submissions of the counsel for the petitioner that he is a cancer patient and requires treatment, and also that his pensionary benefits along with other area P has been withheld. We direct the respondents to complete their instructions and file affidavit within 1 week. Place this matter again on 22nd of September. Please file it within 1 week.
Yes. If my lord, if I can get the instruction.
Yes, yes, take it back. Instructions ready.
Section 28.
File with those.
This is appointment arbitrator wala railway matter.
Who's for the railway? No railway council?
The council wala my junior is calling water.
K. Gokoi in this matter, lordship, post of Gokoi, kindly pass over the matter for time being.
Let us
I will-
wait for him to come.
29.
Malat, it's regarding appointment of the arbitrators, and they have also agreed that by their letter, Milot, reply to our notice, Milot, we suggested the name of S.K. Sharma, Milot. They said that no, whoever may be appointed by the courts.
My lord, lordship may decide, my lord. You may appoint directly, my lord. My client's instruction.
Where is your agreement?
Yes, Milot. At page, relevant portion, Milot, page 19 may kindly, page 19, the relevant portion, that is a para 14, Milot, point number 14. That all the dispute concerning the partnership affairs, if any cannot be settled mutually, shall be referred to the arbitrator to be appointed under the Indian Arbitration Act, so. That is
1940.
14, clause 14, page 19.
Arbitration 1940.
My lord, it is being written.
And where is your notice, 21 notice?
Yes, 21 notice, my lord, I'll, that notice is that at page 63, my lord, 21 notice, my lord. Start from page 63 onwards and 66, 67 is the last. And their reply is start from, my lord, 69. And the last paragraph, if your lordship kindly see, the undersigned on behalf of, that is at page 78, my lord, this is the last page of their reply, my lord. The undersigned on behalf of Osuka so-and-so LLP, formerly so-and-so, without prejudice to aforementioned objection taken against your notice dated so-and-so.
Any reply?
There is a reply, my lord.
This is the reply.
There are earlier, there is our notice that is at page, start from page 69, my lord.
No, no, your notice is at 63.
69, I'm sorry, my lord, sorry.
63.
63, my lord. 63, my lord. Yes.
And
Then their reply, my lord,
Starts from 69.
69, my lord.
69.
Start from 69. Ends at 78.
I heard counsel for parties. This is an application under section 11(6) of the Arbitration and Conciliation Act, 1996. The petitioner and the respondents had entered into an agreement executed by and between them. The petitioners before this court are first party and second party in the deed of agreement dated 13th of March 2019, whereas the respondent is a third party in the said agreement. So, the petitioners 1 and 2 and the respondent entered into and executed this agreement. To carry on a business as agreed to in terms of this agreement by way of a partnership. So, in terms of clause 14 of the said agreement, all disputes concerning the partnership affairs which cannot be settled mutually shall be referred to arbitrators to be appointed under the relevant laws. Stop. Pursuant to the execution of the pursuant to the agreement executed by and between the petitioner and the respondent, and the business which they had agreed to carry on, certain disputes arose between the petitioners 1 and 2 and the respondents. As the same could not be resorted to or resolved mutually, the petitioner invoked the arbitration clause by issuing a notice under section 21. Where is the notice again?
Page 63. Page 63, my lord. Dated 13/6/2025.
2025. Whereby the respondent was called upon to appoint an arbitrator mentioned in the said notice. So, The respondents submitted their reply by a reply dated 10/7/2025, whereby they did not concur upon the name suggested by the petitioners for appointment as an arbitrator. Stop. As a consequence thereof, this application under section 11(6) has been filed. That I have, considering the submissions made by the counsel for the parties and upon perusal of the, you have not filed any objections.
My lord, my reply may be because I objection, my lord.
Huh?
My reply, I have next, my lord.
Reply.
Starts from page 69.
Reply to the notice.
Yes, my lord. That
You have
may
not
be-
filed any objection.
No, my lord.
Although notice was issued on 6/8/25, the respondents did not file any reply to the, file any objections to the petition filed. The counsel for the respondent submits that they have already raised their objections in the reply dated 10/7/2025 to the notice under section 21 issued by the petitioner on so and so date. Stop. The grievance of the petitioners, grievance of the petitioner is that the respondents did not concur on the appointment of the arbitrator mentioned in the notice dated 21. Stop. The respondents' primary objection is that they did not concur on the name proposed in the notice dated so and so. However, it is submitted that they would have no objection if the court passes an
Right.
appropriate order appointing an arbitrator. Stop. Considering the submissions made by the counsel for the parties and upon perusal of the pleadings available on record, this court, under the powers conferred under section 11(6), appoints Mr. M.K. Bhattacharya, retired district and session judge, to be the sole arbitrator to decide the disputes arising by and between the parties.
Who are the others in the district judge panel, my lord? I do not have an idea.
They are in the list. There is a notification.
Oh, yes, sir, I know, but I do not know who are in the list. That is why I do not know the home, because we have to go to the home. My lord. I do not know his. I can find out, my lord, where it is.
No. The gentleman whose name you have proposed, his name is not in the list.
No, I am not. Either CR Sama is there, or CR Sama, or there will be easy access to that, or any others which is, because I do not know.
We consider the issues involved. You leave it to us.
Yes, we are leaving, my lord. We are not pressing, my lord.
Otherwise, the gentleman mentioned in the notice could have been appointed, but his name is not reflected.
I can, apart from the CR Sama may also be appointed because it's DA to.
My lord, my client's only objection is that their prayer may not be accepted on
Okay,
courts.
then,
Yes,
then
because only objection is there.
I left to them.
Mr. So-and-so is appointed as an arbitrator, subject to issuance of written declaration as required under section 12(1), which may be placed before the court. The parties will appear before the prospective arbitrator along with a copy of this order. The registry of the court is also directed to communicate a copy of this order to Mr. So-and-so, whose name, who's the prospective arbitrator, whose appointment shall be confirmed upon receipt of a written declaration.
So we'll appear before vacations, my lord, before fix a date.
Before vacation, if you want, then let it be on 22nd. You submit and get a written declaration, we'll confirm it.
Yes.
22nd September. List on 22nd September. We have not fixed a date. You appear before the prospective arbitrator on any date.
My lord, any date?
22nd, by 22nd, because that is the last week.
Last week.
Otherwise, it goes to October.
Yes, my lord. It will be, I think, 22, 23, 24, whatever it may be, my lord. Subject to the convenience of your lordship.
22nd,
22nd.
miscellaneous day, let it be on. All right.
My lord.
Or 23rd also if you want.
My lord, yes, 23rd will be better.
23rd.
My lord.
High level. Yes, railways.
28.
Any objection?
No, first.
No objection.
Otherwise, lordship,
Any, in
we
your
have
note-
not filed any reply, lordship.
You have not filed.
We have not filed.
Where is the notice?
My lord, at page 65.
65.
Yes.
Name that you have mentioned here, his name is not
No,
included
not
in the
yet.
list.
Not yet. Your lordship, may.
In the list, lordship, any person. On the
All I
list.
heard, counsel for parties is, there is an application under section 11(6), the Arbitration and Conciliation Act. The petitioner and the respondent. The petitioner was awarded a contract for construction of so and so, page number 28. You read Marco Razin. Stop. Thereafter, a contract agreement number so and so dated 20007 or
09.
09.
09. 13.
09 2013 was executed by and between the petitioner and the respondent. Stop. Thereafter, work was completed or terminated or what?
Terminated.
Subsequently, the work stood terminated by the respondent on the ground that the same could not be proceeded with or completed by the petitioner. Stop. Petitioner being aggrieved has invoked the arbitration clause, which is a part of the agreement executed by and between the petitioner. Stop. In terms of the said arbitration clause, where is the arbitration clause?
54, page 32. Same type, my lord.
You issued a notice.
Yes.
Notice was replied or not replied?
Not replied.
Not replied. Invoking the said arbitration clause, the petitioner issued a notice dated 2001-2025. Which was wherein the claims of the petitioner were raised and a demand for arbitration was made, and calling upon the respondents to concur on the prospective arbitrator, calling upon the respondents to concur on the arbitrator mentioned in the notice. So the said notice was not replied to by the respondents. Under such circumstances, the present application has been filed under section 11(6). Stop. The learned CGC representing the railways submits that they have no objection if the court appoints an arbitrator to decide this
As
issue.
per the law, done by the apex court, lordship.
in terms of the orders, judgments passed by the apex court. In central organization.
Central coil field.
Huh?
Central
Central organization
organization for
for
railway electrification.
railway electrification,
Yes, sir.
CORE judgment,
Yes, sir.
and the subsequent judgments thereafter.
Yes, sir.
Correct. In that view of the matter, this court is of the view that in terms of the notification dated 29, dated notification number 29, dated 21st of May 2024, published by the registry, the court considers it appropriate to appoint any choices?
Well, I told my Chayani Goswami, that district judge.
Sayani Goswami Lordship, few matters are arbitration matters pending. So Lordship, any person's Lordship, any, from the list, anyone Lordship. So many matters is there in
Justice C.R. Sharma.
Lordship.
C.R. Sharma may not be appointed.
Oh, okay.
P.K. Musari may be, my lord.
Justice P.K. Mushari, former judge of this high court, be appointed as a sole arbitrator to decide and arbitrate on the disputes arising by and between the parties, subject to the written declaration issued by the prospective arbitrator as is required under section so and so of the Act. The petitioners will communicate a copy of this order before the prospective arbitrator appointed. Registry is also directed to communicate a copy of this order to the prospective arbitrator sought to be appointed by the court. You tell us when you want it.
Well, before vacation, any that, my lord?
23rd?
23rd, my lord.
23rd September.
Item 30 to 33.
They filed my lord in respect of item number 33, my lord. Affidavit.
Lordship, this morning we have filed our affidavit in respect of item number 33, Lordship.
So will it cover all the issues?
No, Lordship, in item 31 and 32 already we have filed, Lordship.
Ah.
So Lordship, 33 we have filed today. They would like to
Reply, my lord.
Reply. All right.
That's the
Counsel for the respondent submits that they have filed a counter affidavit in item number 33, that is WPC 3772 of 2025. Item really case number 2. The counsel for the petitioner claims liberty of the court to file rejoinder affidavit. Accordingly, all these matters will be listed again after 3 weeks.
oblige.
35.
The matter, my lord, personally, my lord, retired executive engineer, and he's retired from service at 28/2, and pension has not been paid, my lord. Last occasion, my lord, while issuing notice, my lord, he asked for instruction. Till now, even my lord, his salary for the month of January and February has not been paid. And recently, my government issued a notification, my lord, that provisional pension can be held up only for 6 months. That too only subject to the approval of competent authority. These are notifications, Lordship, can you see? 6 months has been passed, my lord, provisional pension has been not been paid.
Yes, what is your?
We have the instruction. The instruction states that his salary for the month of February, for 2 months, January and February 2025 couldn't be disbursed because of non-submission of some certain documents, that is the last pay certificate, and he had to transfer his name in Finance Assam portal, and also sought for the salary statement for the month of March 2024 to December 2024, which the petitioner haven't submitted yet. Unless those are submitted, nor the salary can be processed for the 2 months, nor the pensionary benefits can be processed.
You have not submitted some documents.
Ready to be pension.
Pension to is salary to business officer.
What documents are, what documents?
Lordship, Lordship appear is para 19.
That Roman 1 to 12.
Yes, Lordship. Those are for the pensionary benefits and also for the last pay certificate. And he had to transfer his name in Finance Assam portal.
Yes,
So submit the document, my lord. I'll find a copy of that document, my lord.
you file it. You file,
That document I'll file.
all
my lord.
these documents, whether you have filed it or not.
Let us ascertain, my lord. If not file, I'll file it. And kindly ask me to furnish the document, my lord. The petitioner's copy.
Okay, I'll furnish it.
You give him a copy.
Yes.
Mr. R. Borua for the petitioner, Mr.
AK Ghosh. AK Ghosh. On behalf of Mr. Yadat.
on behalf of Mr. S. Dotto, appearing for the PNRD department, submits that certain documents which are necessary in order to process the papers, pensionary papers of the petitioner have not been furnished. Stop. These documents, list of these documents have been placed before the courts by the learned standing council. Stop. There are Mr. Borua on the other end submits that as per his instructions, these documents have already been furnished. However, he would like to complete his instructions on this. Therefore, the matter be listed. It has to come in October.
Yes, sir.
Listed on 17th October. 17th October.
All right, Lord.
That legal. I know the Lordship was pleased to issue notice on 22/8/25. That the petitioner's case was wrongly kept on the seal cover.
Who is for the respondent? Public Works.
On the last reason, Mr. Ardhar appeared, madam.
Lordship, I am calling kindly pass over for the time being.
Let it be on Wednesday or Friday.
No.
Wednesday. List on Wednesday. As the learned standing council, PWD is not available in court. Mr. J. Patwari for the petitioner. Wednesday.
Yes.
Item 37.
Yes, my lord. My lord, in this matter, my lord, we have received our instructions, but my lord, it is not adequate, my lord. Hence, I'm praying for 2 weeks' time, my lord, to obtain the same, my lord.
Somebody has filed an affidavit.
Even my lord, we have filed, and they filed a reply also, my lord.
Then you want to file another affidavit?
My lord. Rejoinder affidavit, my lord. Some actual development has arisen in this matter, my lord.
Additional affidavit.
My lord. Specifically, my lord, with regards to para number 5 of their affidavit in reply, my lord, this honorable court has directed us, my lord, to obtain the instruction, my lord. Accordingly, we have communicated with the department, my lord, and we have received the para-wise comments, my lord, but it is not adequate, my lord.
What is your reply in para 5?
That reply, my lord, we have to get from the department, my lord. In this affidavit, my lord. Now, my lord, our reply is, my lord, the promotion was given by the then Assistant Commissioner of Taxes Dhuburi unit as per the rule taking into consideration the eligibility criteria and roster appointment. Therefore, the question of depriving of the petitioner of the legitimate right does not arise. Short reply, my lord.
Yes.
But in lordship, their affidavit in opposition and referring their statement at page 25, para 4. there are two petitioner. Petitioner number one was promoted, Lordship. And petitioner number one, I'm reading it for
You are now pressing the petition on behalf of petitioner two.
petitioner two.
All right.
Yes. I'm reading from the third line. However, anything beyond the record are denied and disputed by answering deponent. The deponent further actually said that there were 11 vacancies in the cadre of junior assistant in the office of Assistant Commissioner Taxes Dhuburi unit. However, in the cadre of grade 4, there were only 5 staff, out of which one was deputed in other office. As such, promotion of the petitioners considered at that point of time as because promotion of the petitioner to higher post will result in shortage of staff in the grade 4 and it will affect the smooth functioning of the office. So this is their stand.
And what is your reply?
In reply, Lordship, what? Yes, I am my put it in reply, Lordship. Page 30, start from para 5. That with regard to the assignment made in para 4 in the affidavit of respondent number 2, answering deponent begs to state that deponent in petitioner number 1 were not promoted due to the shortage of staff in the cadre of grade 4. In spite of 11 numbers of vacancies were available in the cadre of junior assistant in the office of Assistant Commissioner Taxes Dhuburi unit, but as recently appointed has made for the vacant post. So petitioner number 1 has been promoted to 1 post of the junior assistant out of 4 vacancy posts. It is further stated by the answering deponent that there is no shortage of grade 4 cadre at this stage in the office of the Assistant Commissioner Dhuburi, and as such question of not concerning the promotion of the answering deponent from the post of grade 4 to the post of grade 3 does not arise.
My lord, may kindly peruse page number 20, running page 26 of our affidavit in opposition, my lord.
Right, let them get their instructions.
Not just.
Third council for parties, the respondent council submits that they would like to file an additional affidavit in response to the reply made by the petitioner in paragraph 5 of the affidavit in reply. Counsel for the respondent therefore submits that, therefore prays for 3 weeks. And this again after 3 weeks.
Hello, please, my lord.
Item 39.
Lordship, in this matter, I am filing the affidavit today, Lordship.
They are filing affidavit today. Mr. F. A. Loskor appears for the petitioner, and MSM Bhattacharya, an government advocate, appearing for the state, submits that she is filing the affidavit on behalf of the respondents during the course of the day.
During the course of the day, Lordship.
Accordingly, matter stands deferred, enabling the petitioner to file their reply affidavit if so advised, list after 2 weeks.
Obliged.
Obliged, your lord.
40.
Since Lordship took up the matter for final disposal of the matter, my lord, in earlier occasion, my lord, today only I pray, my lord, can it be taken on Thursday, Lordship, for disposal, my lord?
Thursday,
My lord.
18th.
Yes,
All right, Thursday,
Lordship.
as prayed for by Mr. B. Chetri. Counsel with the petitioner, Mr. J. K. Goswami, additional senior government advocate for the respondents.
Obliged, Lordship.
41.
This is a case where I have prayed for compassionate family pension. The petitioner's husband was an employee of APDCL. He served for 1 year, 11 months and 6 days. They have filed an affidavit stating that the minimum qualification is 2 years, your lordship, for entitlement. So he is falling short by 26 days only. So as there is a mediation drive going on, can I pray for, if your lordship pleases.
Mediation.
Only falling short by 20 days, Your Lordship.
All right, yes, mediation. Mr. B.J. Mukherjee for the petitioner, Mr. Your name?
Bidas, my lord.
Bidas appears for the APDCL. Counsel for the petitioner submits that the matter can be referred to mediation for resolving the claims made by the petitioner in the present petition. Prayer made is not objected to by the counsel for the respondent. List for mediation before the so-and-so committee on 26th of September.
Wonderful.
Item 42 and 43.
Yes.
And for item 14.3 may be taken fast.
43.
43.
Yes.
Matter relates to de novo inquiry, my lord.
De novo inquiry.
Yes. Fresh inquiry was given, my lord. Now, my lord, they have filed also the affidavit in reply, my lord. They have, Your Lordship, kindly see their
Reply or you have filed a reply?
affidavit in opposition, my lord. They have filed. Your
Ah.
Lordship, kindly see their affidavit in opposition.
Wait, first let us see the, where is the order of de novo?
Yes, my lord. Annexure F, page 32. One five. Sorry, Mr. Annexure B, page 21. Annexure B, page 21. From the fourth para, it is relevant, Miller. Whereas the inquiry officer, after completion of the inquiry, submitted the finding that the charges of serious misconduct and dereliction of duty against the charge officer Sri Ajay Kumar Hindik, Inspector UB of Police, are not proved. Whereas the disciplinary authority perused the finding and found not to be satisfactory, as Sri Ajay Kumar Hindik, Inspector UB of Police were apprehended by a trap team of Director of Vigilance and Anti-Corruption Assam for demanding bribe and accepting it through middleman Sri Mukhtar Hussain. This is the ground, my lord. Hence, the finding dated 22/8/2024 is not accepted. The charges may be inquired afresh and a de novo inquiry will be conducted. Now, the question arises that when the de novo inquiry can be given, Miller. Your Lordship, kindly see their affidavit in opposition, Miller.
There are judgments.
Yes, Miller.
Madam,
Lordship.
regarding de novo inquiry.
Only if there is a material irregularity, Miller, then it can be given.
It can't be given on the basis of the disciplinary authority not agreeing to it. You of course have a right of disagreement,
Lordship.
but de novo inquiry, there are judgments. What is the status of the proceedings
It's
now?
continuing.
It's continuing, Lordship. It is not yet completed.
Continuing. We'll have to give a stay. It will be futile to proceed in these inquiry and then lead to further conclusions. Not one, several judgments of this court.
Yes.
Lordship.
Unless you want to distinguish that the order communication ordering de novo itself reveals the grounds on why de novo is called for.
Lordship.
That prima facie appears to be in conflict with the findings of the court. Second last paragraph, page 21.
Yes, Lordship.
According to them, my lord, they have access to the power of provision 6.18.1. The manual.
You examine this matter from the standpoint of the
Yes,
judgment.
Lordship, and Lordship may fix it on any date, Lordship. next week, Lordship, so that this can be
Not next
disposed
week,
of.
not next week. It can't be next week. If you want to distinguish the judgment, it can be
Lordship.
next week. If you say that all right, it is covered, then it can be tomorrow.
No, Lordship.
Oh. I heard counsel for parties. Petitioner is aggrieved by the de novo inquiry initiated against the writ petitioner by order dated 6th of September 2024. The de novo inquiry, it is submitted that the de novo inquiry was instituted against the writ petitioner as the disciplinary authority did not find the conclusions of the inquiry earlier conducted, satisfactory. Stop. Counsel for the petitioner by referring to judgments rendered by coordinate benches of this court in, what is that, Borgohain?
Yes, madam.
Borgohain?
There are two judgments, my lord. One is Bhupati Ranjan Mudoi, and there Borgohain judgment is also there.
In so and so, so and so.
Vidyut Buragohain.
Vidyut Buragohain.
Yes, ma'am.
Reported in so and so, as well as, what is that, Mudoi?
Bhupati Ranjan Mudoi.
Bhupati Ranjan Mudoi. Reported in so and so. That de novo inquiry is not called for under the provisions of the Assam Discipline and Appeal Rules 1964, except to cure material defects which may have occurred during the inquiry instituted para. The learned government advocate appearing for the respondents submit that there is no infirmity in the order. The respondents have already filed their affidavit, and the de novo inquiry was ordered by following the procedure prescribed under the Discipline and Appeal Rules 1964, read with the Manual of Disciplinary Proceedings. Stop. She submits that these judgments can be distinguished on facts. Therefore, the matter should be listed for hearing.
Lordship.
Accordingly, is agreed to by the counsel for parties that the matter be listed for hearing on 23rd October.
23rd, Lordship.
In the meantime, my lord, the impunity may be
It is submitted that the de novo proceedings have already been carried on against the writ petitioner. Stop considering the judgments rendered by coordinate benches in Vidyut Buragohain and so Mudoi and Sunmoni Sinha, reported in so and so. This court is of the prima facie view that coordinate benches have laid down a law that de novo inquiry is ordinarily not permitted, but to correct material irregularities. Stop. Therefore, while this court permits the de novo inquiry, while this court has been informed that de novo inquiry has been proceeded against the writ petitioner, the conclusions thereof may not be or you say no adverse orders may be passed on the basis of such inquiry being conducted by the disciplinary authority without further leave of the court. List on 23rd.
obliged.
What about the other matter?
Other matter is suspension. my lord.
Suspension, Lordship.
Still under suspension, my lord. More than 2 years.
Then both these matters will be listed on so and so date.
Item 44.
Obliged.
Yes.
My lord, I'm appearing on behalf of my senior Mr. K. Bhuya, my lord. My lord, herein I'm the petitioner, Parishmita Pathak, my lord. My lord, I'm seeking 50% share of family pension. And my lord, I'm also seeking
Who
the
are you?
release of.
Who are you?
My lord, I'm the daughter of the first wife, my lord.
Daughter of?
The first wife, my lord.
First wife.
Yes, my lord.
What happened to the first wife?
My lord, she's at home, my lord, but I'm still our family is facing a lot of financial hardships, my lord.
Who is you are for respondent 6?
No, my lord,
You are for the petitioner.
I'm the petitioner, my lord.
And who is respondent 6? Who is respondent 6?
Dulumoni.
Second wife of Mr.
Now, what is your dispute here? Who is getting the pension?
My lord, respondent number 6 is getting the pension, my lord, and also she has already received the GIS savings, the gratuity, and almost everything by forging the next of kin certificate, my lord.
Forging?
Yes, my lord, because like legally, I should have also been made part of the next of the kin certificate.
Have you made a complaint against this?
Yes, my lord. My lord. My lord, if I may kindly direct your attention towards Annexure 7, my lord. Under Section 80 of CPC, my lord,
Yes.
a representation was made, my lord, seeking for.
What happened then?
My lord, no reply was given by the respondent, my lord. Even till date, my lord, nothing.
Whose name is there in the nomination department? Nomination?
As per next to kin certificate, lordship.
No, next of kin we have seen. Is there any nomination?
No, regarding nomination, no.
My lord, through filing RTI only, I was able to know that all of this has happened, my lord.
First wife was divorced already, lordship. And
Divorced?
yes, lordship. And she got the maintenance as per the order of family court, lordship. Order dated 28/1/2011.
How old are you?
My lord, I'm 20, my lord. My lord, I'm still a student, my lord. I'm studying studying BA, my lord, and I'm currently in the 6th semester, my lord. So I cannot go look for a job, my lord, because I have to focus on my studies, my lord.
What does the rule say? Pension rules?
My lord, pension that there can be only one beneficiary where like the money would be transferred to a particular account, my lord. However, my lord, if I may mention, my lord, a judgment of this honorable court, my lord, Kankana Deka versus the state of Assam, my lord. My lord, if I may kindly direct your attention towards para 6, my lord. My lord, it's a similar case, my lord. Only the difference is that here the second wife's daughter was legally entitled, my lord. And here, my lord, it's the opposite case, my lord. I'm the first wife's daughter, my lord. My lord, here in para 6, my lord, the court has said that by requiring the amount to be paid to the eldest of the surviving.
This is the judgment you show us from the rules. What does the rule say? Pension rules. You are governed by the pension rules. Pension is to be released by in terms of the rules. What is the mandate of the rules?
There can be only one person who gets the pension, my lord.
And then?
My lord, but I am legally entitled, my lord.
No, you have not looked into the rules. Look into the rules and come back.
Yes, my lord.
Look into the rules.
Yes, my lord.
There are subsequent provisions amended.
Yes, my lord.
On the request made by counsel for petitioner, matter stands deferred to be listed after 2 weeks.
Lordship, we have not received the affidavit in opposition filed by respondent number 3 and 4 and also the reply filed by the petitioner.
Why don't you serve copies?
Yes, my lord.
Do it in the course of the day.
Yes, my lord.
Filed our reply.
File your reply. We're not stopping you. Matter is already deferred for 2 weeks. You file your reply if you want to. We are not stopping you. The councils will ensure exchange of pleadings amongst the parties before the court.
I am for 1, 3 and 4.
MSS Borua for respondent 1, 3 and 4.
4.
MS R Soikia for respondent 2. MS
6, Your Lordship.
MS so and so appearing
Shortly.
on behalf of respondent 6. All right.
Second 45.
Matter relates to pension, non-payment of pensionary benefits, Lordship. In the morning, Lordship, CDC has told me that he has some difficulty today. He is in Mizoram.
Who?
So, Mr. S.K. Medhi, Lordship, S.K. Medhi. So,
It is informed to the court that Mr. S.K. Medhi, CGC, is representing the respondents, is not available in court. Therefore,
Lordship,
let this matter be listed again after 2 weeks.
Lordship, I got it listed because of pension matter by order.
Hmm?
Because of, I got the matter listed by order, Lordship. So, Lordship, may I pray that
Fix it on Monday.
they have also no difficult, Lordship, if Lordships.
Monday.
Monday, Lordship,
Right, as
because
agreed to by council for parties, list on Monday,
Lordship,
22nd.
Lordship,
Obliged.
oblige, Lordship.
Yes.
May I please, Your Lordship? Lordship, may I kindly peruse the last order passed by the Lordship?
Status of the departmental appeal?
Yes, Lordship, it has already been disposed of on 7/12/2024, Lordship.
It is not yet communicated to us.
Is there any copy that you can share with the council for the petition?
Yes, Lordship, or else shall I put it on record, Lordship, through an affidavit?
Disposal, you just share it, let him under, you give it, you give it to the court master, we'll keep a copy on the record also.
Lordship. It will.
Mr. P.P. Bhattakur for the petitioner, M.S. N. Bhattacharya, an additional senior government advocate for the respondent. It is submitted that the appeal. This is against what? Dismissal?
Dismissal, Lordship.
The appeal preferred against the dismissal of the writ petitioner before the appellate authority has been disposed of. Has been disposed of.
Yes, Lordship, appeal.
By rejecting,
Yes, Lordship, it is been
by
rejected. Lordship.
dismissing the appeal. ID order dated
7/12/2024.
7/12/24.
Yes, Lordship.
Stop. The counsel for the petitioner, however, submits that the writ petitioner was not aware or informed about the dismissal of his appeal. He prays for 2 weeks' time to complete his instructions on this. You have to decide now what you want to do.
Yes, yes. And one more prayer. Actually, what happened, Lordship, during pendency of, before filing of the writ petition, I filed one RTI application before the authority and subsequently another one for asking for the relevant documents from the inquiry proceeding. But they have not provided, always misleaded the petitioner by replying some other, it is already on record, my lord. So now I came to know that the entire record is with my learned friend. May I have a copy from the inquiry?
That is between you and your learned friend.
Yes, it is already here.
Huh?
Already with my, as per direction.
It is not for us. It is the records of the department. If she is willing to give it to you, we have no
I have
complaints.
already made 2 applications.
No. We can't issue directions to the council to hand over records.
So much.
If your RTI is not replied, there are again appellate.
Yes, Lordship,
Go and
there
file
are
appeal.
for us. Yes, Lordship.
Don't make prayers that we can't give you. How much time do you now require to complete? 2 weeks.
1 week, Lordship. After, before Puja vacation.
Before puja is not possible. Not possible.
2 weeks.
You enjoy your puja, think about it and come back. What you want to
Just
do.
opening
List
of
again
the-
immediately after reopening of the court.
Date may be fixed, my lord, any date. after-
15th of October,
Please.
15 October.
Oblige, your lordship.
I think 47, 48, and 49.
Not legal, okay. Let the petitioner before your lordship are RA constable, my lord, who has been medically found unfit for the post, my lord, but they have been found fit for C categories of job. My lord. Therefore, what happened, my lord, they have been appointed as a cook, but the cook falls under B1 category of job, my lord. And my lord, we have submitted representation that is also pending, my lord.
Yes.
Lordship, we have filed our affidavit and all. Let this matter come up after vacation. So means since
Madam,
Mr. Roy is out of station.
More than 6 months, my lord, we are not getting our salary.
And
my
we
lord.
will
Mr. Roy is already on vacation.
No, he'll be back soon, but then again, let this matter come after vacation, Your Lordship.
You are now appointed as a cook.
Cook, my lord. But we have not joined, my lord. And therefore, my lord, we are without salary for the more than 6 months. My lord.
Is he available next week?
Yes, Your Lordship, he will be, yes.
Then let us have it on 22nd.
Perfect, yes, Your Lordship.
22nd.
Yes.
On the request made on behalf of Mr. CGC, matter stands referred to be listed on 22nd. Mr. I. Rafiq appears for the writ petition.
All right.
Item 50.
Item 58, Lordship, I have received one instruction, Lordship, I have given this instruction. Lordship, kindly be paid with this instruction. Some process is going on, Lordships.
Yes. How much time?
This is under process.
Then why don't we close the matter? They have made a statement that file will be endorsed to the finance department. Okay. Now we have the holidays. Let it come after the vacation. Mr. MS so appears for the petitioner. Mr. Hendik, standing counsel revenue, submits that the papers are regarding the release of area salary. Regarding the release of salary in respect of the writ petitioner is under process. And thereafter, the file will be endorsed to the finance department. Stop. He therefore submits that the matter be listed again after 2 weeks. List this matter again after 2 weeks.
Okay. If that instruction.
We kept it in the case record.
Lordship.
Yes.
I am agreeing for one.
MS S. Burwa appears for respondent 1.
Item 51 and 2.
May I please, your lordship? Your lordship, may we seek further 2 weeks' time to reply to the affidavit in opposition, your lordship?
Counsel for petitioner prays for further 2 weeks' time reply to file rejoinder affidavit to the affidavit in opposition. Mr. M. Sharma, learned counsel representing the UCO Bank, does not object to the prayer made just after 2 weeks.
No, not
Or you object?
objections may be given.
What objections?
No, there is no objection, but since the entire transfer has been stopped by this order. So otherwise I am not objecting, but only the word, my consent may not be just to.
You have an interim order in your favor.
Yes,
Yes,
Your
yes.
So when do you want to file your affidavit?
In 2 weeks after vacation, 2 weeks time.
Mr. M. Sharma appears for the respondent. He submits that there is an interim order in favor of the petitioner, therefore there is urgency in the matter. Urgency in hearing of the matter. Accordingly, let this matter be listed on 15th of October.
Much appreciated.
53.
Back to your lordship. Lordship, by the order dated 13/8/25.
Lord, in this
I have to
matter,
file affidavit, but they have
I
not
need
filed one.
some time to file affidavit. Lord.
Affidavit not filed.
Yes, my lord. I need some time, my lord. I have not received the Paravest comment, my lord. 2 weeks time may be granted, my lord.
Right. Mr. J. Patwari for the petitioner, Mr. D.P. Bora for standing counsel help. Prays for further 2 weeks time to file the affidavit. Counter affidavit. He submits that his instructions are not yet complete. Accordingly, list again on 24th October.
Yes.
Interim order has to be continued.
Interim order past review will continue.
Deep level.
Can it be on 27, my lord?
27th.
Yes, my lord.
27th.
Obliged.
Deep.
Documented is for admission item 70.
Yes.
My lord, on the last occasion, there was a direction from this honorable court to file an amended cost title, my lord. I've heard on that regard, my lord. I'll do in the next 3-4 days, my lord. And I understand, my lord, that the forest department has received instructions, my lord. That was what I was told.
You file your cause title first.
My lord, I'll do that, my lord.
Counsel for petitioner is permitted 1 week's further time to file the amended cause title before the registry. Matter be listed thereafter.
My lord, I'm grateful, my lord.
Itu matter. Maribo, you might look out. 54.
Item 54.
May it please your lordship, my lord, here, my lord, basically, I'm challenging the removal order, my lord. Which your lordship will find at page 48. But, on, my lord, 13/6/2008, lordship, I kindly
It was
come-
not communicated. Enquiry was not communicated.
Your lordship,
Enquiry order.
inquiry order was at the time of passing the impugn order, inquiry report was not communicated to him. But subsequently it was communicated.
But it was on
But
the list
he
of the-
participated in the proceeding.
That's right. But before passing the
Yes.
impugned order, you have to communicate.
Yes, yes, about to have been communicated.
It was not done.
It is not done.
So what is to be done now?
Well, not only that, my lordship, my lord, my case is, my lord, even my lord, rule 9(2) has not been complied because, my lord, lordship, even also comes to the Soakers notice, my lord. There's no mention of any list of documents and list of witnesses. So documents, my lord, which rule 9(2) says had to be, my lord, invariably, my lord, furnished to me along with the charge sheet, my lord, that was also not given. My lord, my lord, fundamental right to, my lord, defend and, my lord, to defend my case, to deny the guilt was denied, was not given to me.
You see, unless you serve a copy as per the mandate of law.
Yes, your lordship.
It has to be interfered with.
Your lordship, the is the second round of writ petition also litigation. In the first litigation, they challenged the entire proceeding. The court was pleased to not to interfere. Your lordship, now your lordship, they are challenging the order of dismissal, saying that
No, but in terms of the law laid down by the.
yes,
apex
yes,
court,
definitely. Your
You
lordship.
did not serve.
But your lordship, the thing is that your lordship, if he is aggrieved, then your lordship, there is a remedy available in the statute itself.
That will come pursuant to you
Yes.
fulfilling the mandatory requirements.
Your Lordship, that might be might be a good ground for his appeal, Your Lordship. Departmental appeal.
Huh?
It might be a good ground for departmental appeal, Your Lordship, statutory appeal.
No, why statutory appeal? The disciplinary authority must give him an opportunity, apprise him of the findings.
Yes.
And
Let him-
so that he gets an opportunity to impress upon the disciplinary authority to take a favorable disposition so far as he is concerned. What is his status now?
He has retired in the month of November 2000.
Where is he now?
My lord,
Where is the person now? Dead or alive?
he's alive.
He's
He retired
alive.
in the month of November 2024.
24.
Yes. In a similar case, I have given the judgment also, Malal Gunakanta Thamuli, Malal, 2015 1 ZLT 237. Malal, it squarely covers my case. Also, there is a case of a coordinate bench, Malal. Rashi, may kindly have a look at it, Malal. Rashi, may kindly complete the judgment once.
Yes.
Yes. Rashi, may kindly come to para 28. The same thing had happened in this case also, Malal. No list of documents was furnished to the petitioner. And ultimately, the Honorable Court held this. The Honorable Court said, noted the charge against the petitioner is quite serious, but at the same time, it must also be recognized that the petitioner is entitled to a fair hearing, which is manifest under Rule 9 of the 964 rules and as per law laid down in the decisions of the Apex Court. The departmental proceeding drawn up against the petitioner was required to be conducted in accordance with law, which unfortunately had not been done in the present case. The impugned order has been passed in gross violation of the principles of national justice and also in violation of the procedure laid down under Rule 9 of the 964 rules. The same is therefore wholly untenable and calls for interference. In normal course, after setting aside the order of penalty, court would have given liberty to the disciplinary authority to commence the disciplinary proceeding de novo. But since the petitioner had attained the age of superannuation in the interregnum at this point of time, court is of the view that it would neither be appropriate nor desirable to permit holding or departmental proceeding against the petitioner if raised. Same thing had happened here also, Manoj. The petitioner was not served with a list of documents, list of witnesses, nothing, Manoj. And even the documents are not furnished to him. The Honorable Manoj had held that since Manoj, the 1972 full bench decision is there, Manoj, which says Manoj that Rule 9(2) is mandatory. And even subsequent to that, in 1987, Manoj, the Madhav Chandra Das case, there also the Honorable Division Bench held the Rule 9(2) is mandatory, Manoj.
What do you say with regard to the judgments pressed?
Your Lordship, my humble submission is that his submission hit by res judicata doctrine of constructive res judicata. Because in the earlier petition,
where is that earlier order?
Your Lordship.
Lordship will find.
Page number 44 of his petition, Your Lordship.
How is it res judicata?
Yes. And I don't know Manoj, from where Mr. Nawal is making this statement because the copy of the writ petition is not with me. Or else Manoj, he must be having the copy of the already writ petition.
This is your writ petition. If you
This is the order passed, Manoj. Here, Manoj, it is not stated.
No. Who has filed this writ petition?
Me, Manoj. He is talking about the earlier writ petition filed by me.
So how do you make a statement that you don't have a copy? You don't have a copy, you apply for a copy. Get it. Tell us.
No, he is saying That my lord, I had challenged the proceeding there, my lord. From where he's making the statement, my lord.
The order itself.
No, order doesn't say, my lord, I had challenged the proceeding. It was, my lord, what I understood. What I understand is, my lord, that the proceeding since was pending for a long time. So the petitioner had come for, my lord, with a prayer to, my lord, to conclude the DP. That's what I understand from this order.
Finally, DP was directed to be concluded within a period of 2 months.
Yes, it was done, man. Only 8.
The order of dismissal was not there at the time.
No, it was not there.
But so far as the defect in the proceeding, your lordship, non-submission of documents, etc.
Even if we don't take that up, the fact that you did not serve a copy.
Yeah, that is admitted, your lordship.
So if that is admitted, then your proceeding order has to go, matter has to go back
Your
to the
lordship,
stage.
your lordship, there are two options, your lordship. Your lordship may directly interfere, or your lordship may directing the petitioners to giving him liberty to file a departmental appeal. Because statutory.
What you are asking us to do is to give our powers or relegate our powers to the
Your lordship,
appellate authority.
Our submission is that he never exhausted the statutory.
How can he, when you did not give him a copy?
Your
You should have
lordship,
given him a copy then and there. Copy of the inquiry
he
report.
received by letter, or he filed an RTI and he received the copy.
It was subsequently, my lord. After the order was passed.
It is not that he never received it.
No, after the order was passed.
All right, we'll pass some order on Thursday.
My lord.
Yes, sir.
List on Thursday.
But can it be on Friday, my lord?
Let it be on Thursday for the time being.
Thursday, my lord, has some divisions. Yes.
So what can be done? This is a 2013 matter. You are lingering it on.
Yes, my lord.
You are asking that you are pressing the judgment of a coordinate bench that
Yes, my lord.
is not practicable. Now tell us, why is it not practicable, and whose instance the matter has lingered for last 12 years? Whose instance? Can it be attributed only to the respondents?
No, my lord.
Then
Definitely not. Even I am responsible for it, my lord. I agree.
if you are responsible, then you're not entitled to an order.
My lord. So was delay is concerned, otherwise, my lord, on
But
merit.
ultimately, this institution is answerable
Yes.
for 12 years.
All right, my lord. Let it be on Thursday, my lord.
All right.
55.
May I please, your lordship? Lordship, I pray for a short accommodation, my lord, on account of senior advocate being unwell, lordship.
Let it be after vacations.
Lordship, can it be on 22nd, lordship?
No. That's to be after vacations. That will be listed after the in the month of October. In the month of
Lordship, if a date may be fixed, my lord. After the puja vacation.
You make a mention and fix a date after vacations.
Lord, just
Yes.
one line as direction, earlier direction, Lordship. I have already obtained the records, Lord.
Whatever, keep it.
Lord.
Records obtained by the learned additional AG pertaining to the present proceedings may be produced on the next date fixed for perusal of the court if the need so arises, list on 30 October 30.
Lordship.
30.
No, bless my lord.
Lord.
56.
Yes.
There we are challenging the order, Lord, by which, Lord, the petitioner was terminated without holding any departmental inquiry. Lordship says page 34.
34. There was some inquiry held,
No, my lord.
but the order itself reveals inquiry report dated so and so. Second para,
My lord.
page number 34, second para.
29/6/23.
But this is something which they did of their own. But is regard the FIR that has been lodged against the
Very PS
petitioner.
case.
My lord, kindly have a look. At page 29, my lord. Query contemplated would be under the departmental proceeding law.
They've invoked 311.
2B.
My lord, kindly see page 29.
Maybe. You were suspended.
Yes, pending departmental inquiry.
Hmm.
But in one day, but they come to a conclusion that I should be suspended pending departmental inquiry. And next day, my lord, they terminate me without holding any inquiry.
Oh, 1 day.
Yes.
Lordship, since 29 June, from the date when he was suspended, Lordship, he was absconding arrest, Lordship.
In
He
23rd
was involved
and
in a
30th,
POXO
you
case.
terminate him. Within 1 day.
1 day, 1 day.
Lordship, we have filed our affidavit, Lordship.
No, where?
How do you defend it?
But we have not been served a copy.
Without service, how can an affidavit be filed?
Lordship, I'll serve him a copy. I actually filed this affidavit on Thursday, Lordship. Copy should have been served upon me. One eye copy. Lordship, I may be allowed to serve him a copy today itself, Lordship.
But only thing is, Lord, the petitioner is
Mr.
retiring
for
next
the
week.
petitioner, MSU Sharma for the respondents. The respondents have filed an affidavit on 11 September
Okay.
2025. Stop. Counsel for petitioner submits that he will not receive the copy of the affidavit. Learned government advocate assures the court, submits that she will ensure service of copy within the course of the day.
Lordship.
Then
Can your lordship take it up urgently, my lord, because he is retiring next year, next month, my lord, October.
next month,
He's already dismissed.
urgently, because affidavit not filed.
But time and again, your lordship has called for the record as well as affidavit.
Record is available, Lordship.
A small issue, my lord.
No, small issue, but the order may not be small. That is where the problem is.
I understand.
Issues are small. I wish we could write small orders for small issues, then no problem.
No,
But we'll make an attempt. Let it be immediately after reopening.
But then can I pray for a fixed date, my lord?
Yes. 14th October
14th October.
or 16th October. Let's list this matter on 16th October. The petitioner may file rejoinder if so advised in the meantime. List accordingly.
Deeply obliged.
Yes. Yes.
Item 59, 57.
Yes.
May I submit, Lordship?
My lord, want to place, my lord, that because about the meeting, my lord, they have not said anything, my lord, how the committee is formed, how this, my lord, and with the, my lord, affidavit of the IA, my lord, we have annexed a copy of the affidavit, my lord. Filed earlier. There also they have not mentioned about the meeting, my lord.
No, according to you, this organization was taken over by the state.
State.
In terms of the guidelines given by the government of
Well,
India.
Yes, mission something.
And your appointments are now sought to be terminated by inviting fresh applications.
Yes. Yes, my lord. Oh, and these are also temporary, my lord.
Whatever.
Yes. So, replacing one temporary by another temporary, my lord.
No,
If they appoint some regular, my lord, post regular appointments.
No, how can it be regular? This is a scheme.
My lord, yes.
Regular appointment.
Temporary, my lord, they could have, my lord, because we are serving so long, my lord, we have got
Why is there any scope for consideration of their services individually? Individual basis?
Individual basis, my lord.
Not participated in the process, lordship.
No, no.
They have not, lordship.
They are not.
There was an open advertisement, but they did not participate, lordship. They choose to remain abstain from this, participating in this process.
You did not participate.
My lord, actually we are working, my lord. My lord. We challenge that, my lord, advertisement.
All right.
My lord, my lord, if your lordship see, my lord, they are meeting, my lord. They allegedly given the meeting, my lord.
You're referring to which, the writ petition?
No, my lord, IA.
IA.
IA in 1665.
1665.
Yes.
No, IA 2241.
2241. Yes. 2241.
Yes.
My lord. At page 18, my lord, that they have annexed a copy of the minutes of meeting, my lord. Of the district level committee.
Yes.
And I do not know, my lord, how the district level committee has been formed. That is also not known. Here they have shown, my lord, that 9 persons are present. My lord. Here, if you also see, my lord, the second para in the, my lord, moreover, the dear present in the meeting also placed before the house his dissatisfaction with the functioning of the OSC, Borbetta Post, the expiry of the agreement with the NABARD NGO. Further, we appraise the house that OSC has been taken over by the Office of the District Social Welfare Officer, Borbetta, upon expiry of the deed of agreement on 2010-24. But the staffs were engaged by the NABARD, the then implementing agency, and therefore no punitive action could be taken against them. Well, I do not understand, my lord, because they are paying the salary, my lord, why they cannot take action? Prior to 15-10-24, if any dissatisfaction arise in regard to any of the employees of the OSC appointed by NABARD, then the modus operandi was to inform the matter to the NGO NABARD to take corrective measures in regard to that. He cited the case of Kaveri Soikia. She is the main culprit, my lord. She, Kaveri Soikia, who was serving as Central Administrator, Borbetta, on 1/4/2022 to 15/10/24. Kaveri Soikia has been terminated with NABARD by letter dated so-and-so, but on expiry of deed of agreement with NABARD so-and-so, there is no provision with the district administration or so Borbetta to issue so-called notice to any of the staff or to terminate them. My lord, this is peculiar, my lord. If they are, my lord, taken over and paying the salary, they cannot issue that notice, my lord. On hearing the matter, District Commissioner Borbetta placed before the House the proposal of conducting fresh recruitment process and engage new staff for smooth and effective functioning of the OSC, my lord. Where is the scope of, my lord, following Mission Shakti guideline? The decision was taken as a part of the direction given by the Director, Women and Child Development, Assam. What the direction has been given? I don't know. The House decided to go for fresh recruitment of staff of OSC as per Mission Shakti guideline and as the points below mentioned so and so. A committee was formed to carry out the recruitment process of one-stop center Borbetta. The additional district commissioner Borbetta, district social welfare officer, and child development officer Borbetta. Any other member district commissioner may deem fit. recruitment will take place so and so, my lord. This is the my lord.
No,
And,
what is your,
my lord, now if
what
you
is
also
the-
see page 21, my lord, page 21, you'll also see
21?
21. These signatures, my lord, how they have, my lord, what the committee, my lord, who has formed the committee? My lord, let them produce the constitution of the committee first. Who has constituted a committee and who are the members? Huh?
Where is that guideline?
Yes, guideline is, my lord, in the another next person, my lord, 3476. The 3476, my lord. At page 53. Page 30, from 30 it begins, my lord.
In terms of the guideline, how is the committee to be constituted?
My lord. The first state level committee, then the overall implementation of the scheme of the district level will be done by a committee headed by district magistrate, district collector. The committee will be serviced by the officers in charge of the women and child development department. The other members of the committee will be nominated by DM or DC, drawing officers from the concerned department like education, health, police, skill development, banks, FI, etc. on similar lines as the state level committee. The committee will also prepare the annual action plan for the district, block and villages, so and so, so and so. Okay. This is the matter.
So it is to be drawn up in the similar lines
But
as.
state level committee is not formed till now, my lord. State level committee, if you also will see, my lord, first overall implementation of the so and so, so the committee will be serviced by the Department of Women and Child Welfare Department concerned. This is headed by Chief Secretary. The department concerned state UT. The other members of the committee will be nominated by Chief Secretary, drawing officers from the relevant departments like so and so, so and so, so and so. This is my lord. So here, my lord, they have not informed the Chief Secretary, even my lord. Huh? My lord, in the minutes also there is no forwarding, nothing is there, my lord. If you have seen, my lord.
No.
In the IA, my lord, I have just said, my lord, at page 18.
State level committee is to be constituted.
Yes.
Now.
This has not been forwarded.
Guidelines are not clear as to whether each and every action of the district committee is to be supervised by the state level committee. It says the state committee will meet at least twice a year and monitor the projects.
But one committee is formed by the Director of Women Child Development Department, my lord, earlier. That is regarding, my lord, district level selection committee. That is formed by director. Now they issue fresh committee, my lord. That you'll also find, my lord, in the situation.
There is no clarity from these that it cannot be done, or the particular pattern has to be followed, etc.
My lord, it is there, my lord, but I think, my lord, they have not informed anybody. And moreover, if you also see that committee formed by the director at page 69, my lord, 16665.
Yes.
This is the district level selection committee constituted under the district admission of the following members in connection with the matters into recruitment of functioning of one-stop for multi-purpose workers and security guard admission against the vacant post. So this is formed against the vacant posts.
You're referring to which page?
Page 69.
On the writ petition.
Writ petition, mother.
69.
In the state level committee,
It will take this is the committee, my lord, formed by the director, additional district commissioner, district social welfare and child development officer.
No, 69 is referring to some posts, position.
Yes.
Then in your losses may see, my lord, at page 3476, my lord. There may be some mistake, my lord. In the writ petition 3476,
That is what we are looking into.
Yes, 3476 at page 62.
62.
62. Director has formed a committee, my lord. This is district level selection committee.
But you have to call out your rights.
My lord.
What is your right to continue in the post?
So my right, my lord, my right is this.
Is it on a particular tenure or something?
No, not tenure, my lord. My question is this, my lord, I am challenging the coordination that they are, my lord, we are the temporary employees. Without appointing a permanent, my lord, for temporary, replacing the temporary employee with another temporary employee.
But that is a
that is, my lord,
that is a proposition that you can urge against the fixed employment. I mean, regular posts, let us say, in the government. These are all posts in the scheme.
But that Pyara Singh case, I am relying on, my lord, that, because temporary employee should not be replaced by another temporary employee, my lord. And moreover, if there is anything, my lord, against any of the employee, they can well necessarily issue the notice terminate. Well, they say that they cannot take any action. Well, this is also wrong, my lord. They are making the payment of their salary and they cannot take any action.
All right. Anything more?
And termination, my lord, later you will also see, my lord, the termination, how they have been terminated.
Page number?
And 89 in the 3476.
Yes.
In persuasion on Guwahati High Court order and termination deed of agreement between so and so, Guwahati, I am directed to inform you that engagement of with the Shakti one-stop center Borpeta will be terminated with effect from so and so, which is 60 days from the date of his notice. The decision has been necessitated due to conclusion termination of the agreement between District Social Welfare of Borpeta and the North Voluntary Organization so and so NABARD, Kailipara, Guwahati, under which your service was engaged. As such, the position you currently hold will cease to exist beyond the above mentioned date.
What is this High Court letter?
High Court letter.
Is it a communication of some order?
His Lordships, there was a direction passed by this Honorable Court,
Yes,
Lordship.
that was the
And in that case, Lordship, this is 25/3/25 order, Lordship, passed in this case, Lordship. 166/525. In this matter, Lordship, there was a clear direction, Lordship, that they have to be issued with a notice of termination as per their condition. That means the engagement letter, Lordship. This is there. 25/3/25, Lordship.
Where does one find it?
My lord, in this IA, my lord, they have next it.
In the IA?
I. At page 51. IF. In IA, my lord. It starts from page 39, but the operative portion, main portion is at page 52.
This is 27C.
No, sorry, no, not this, my lord. I'm sorry, my lord. Not the earlier one.
This is in the Lordship, in the court record is there, Lordship. Order passed by this Honorable Court.
It's a 1084. Or 3476. In 3476, next 84. Yes. 3476, my lord. 84 page. Operative portion is 87, my lord. That can be similar. The last para. Having regard to the facts and circumstances, it is hereby provided that the respondent number 4 may go ahead the appointment process as per advertisement notice if so advised. However, appointment of the writ petitioner shall not be disturbed in any manner without serving 60 days prior notice as per terms and conditions of the contract if they are still functioning as Sakhi One Stop Center in the district court. Is the order, madam? The advertisement is in respect of all the posts, madam. They have not find out who is not working properly, madam.
But in this writ petition, at your instance, court had permitted the respondents to serve the notice 60 days.
Yes.
Yes.
But then these issues of you being temporary workers replaced by another temporary committee is not being formed, these are issues not
No,
our.
this is interim measure, madam. This is interim measure, madam. This matter is now a final hearing, madam. Stage. This is interim measure.
It's the same matter that we are taking up.
Yes.
Yes, sir.
Okay. But this is 1665.
That is the first case, madam.
It is the lead case, lordship, and the order has been passed.
One-
In this order along with the other
Where,
writ petitions.
where are your appointment orders?
One six three. Find this case. 1665, additional affidavit. In 1665, we have filed some additional affidavit. There we have given the additional affidavit. Page, my lord. Your lordship will find page 81, my lord. No, yes, it is. Additional affidavit, my lord. Appointment letters are page 75 onwards. 75 onwards in the first case. First case, page 75 onwards.
75.
In the additional affidavit.
75 page. First case means 1665.
1665, my lord. The additional affidavit is there.
Where is that?
Page 75.
Page
75.
75. 75.
Yes.
Seven-
Additional
Okay.
affidavit, my lord, starts early. Starts from 69. But it is next are 11 series. All the appointment letters are there.
Okay.
You lost got it, madam?
Yes.
This is that. Now I'll send this one judgment of the Supreme Court, madam.
This is about regularization.
No, my lord, paragraph 21, 22, my lord. Oh, that is paragraph 21, 22, my lord. The High Court has placed undue emphasis on the initial level of the appellant's engagement and outsourcing decision taken after the dismissal. The courts must look beyond the surface levels and consider realities of the employment, continuous long-term service, indispensable duties, absence of any mala fide or illegalities in the appointment. In that light, refusing regularizing simply because the original terms did not explicitly state so, or because an outsourcing a policy was belatedly introduced, would be contrary to the principle of fairness and equity. The pervasive measure misuse of temporary employment contracts as exemplified in this case reflects a broader systematic issue that adversely affect the workers' right and job security. In private sector, the rise of the gig economy has led to an increase in precarious employment arrangements, often characterized by lack of benefits, job security, and fair treatment. Such practice has been criticized by exploiting the workers and undermining the labor standards. Government institutions entrusted with upholding the principle of fairness and justice bear an even greater responsibility to avoid such an exploitative employment practice. When public sector entities engage misuse of temporary contracts, it not only mirrors the detrimental trends observed in the gig economy, but also sets a concerning precedent that can erode public trust in government person. But here, that is why I'm submitting. We are working there since 1920. February.
2020.
2020, my lord, yes. 2019. 2019, my lord. 2019, February 2019. So last 6 years, my lord, we are working. Should our services be dispensed with, my lord, without, my lord, considering my proper service, my lord? If any adverse thing is there against me, my lord, necessarily I can be, my lord, taken care of, whatever. But without anything, my lord, because we are experienced in the job, my lord, for the last 6 years.
Yeah, blanket man.
So blanketly, all the persons will be terminated, my lord.
Yes.
Lordship, the petitioner here, they first their challenge was the issuance of notice of the staff of Mission Shakti Lordship. So this advertisement was of 4/3/25. Then immediately after that, they were before your Lordship. Then there was an order of this Honorable Court on 25/3/2025 Lordship, where the Honorable Court has already observed that it was observed that there should not be, they did not interfere with the appointment process, Lordship. The appointment process was given to go ahead. And in the meantime, Lordship, on the submissions of the counsel for the petitioner, Lordship, regarding the termination, then the Honorable Court observed that without the prior notice of 60 days intimation, Lordship, which is as per their term of engagement. So these have to be complied by the respondent authorities. So on the basis of this, Lordship, we served them the notice, and the notice was served on them on 29th April 2025, Lordship. Thereafter, Lordship, on the basis of on this order has been challenged to a writ appeal, Lordship. Writ appeal number 205/2025, Lordship. But in the meantime, Lordship, the selection process took place, Lordship. When the day before the selection takes interview, Lordship, the petitioners were again before the court by filing other set of writ petitions, Lordship, which are connected with this 1665/25, Lordship. Then Lordship has observed, and in the meantime, Lordship also did not interfere with the selection process. Lordship just protected the petitioners on that particular time, Lordship. On that day, I did not have any written instruction, but on the next day, some written instruction was there. But even then, Lordship, as no affidavit was filed, Lordship also, another continued with the petitioners were protected, Lordship. Lordship, admittedly, Lordship, the present petitioners, they were not engaged or selected by the district authorities or the DLC or whoever is be. Here, they were engaged by the other, that means the agency who were in contract with the mission, as per Mission Shakti guidelines, Lordship. So the admitted position is that the present petitioners were engaged by the private agency who were in contract with the department to go ahead by the project of Mission Shakti, Lordship. So as per the Mission Shakti guidelines, Lordship, the district administration is authorized to engage staff.
as earlier there was a contract between the district and the private agency, Lordship. So the private agency, they recruited the staff and accordingly they were put into different positions, Lordship. So presently there is a district level committee, Lordship, and as per Mission Shakti guidelines and the district level committee, they recommended that the fresh engagement to be taken place as the term, the contract were over in October 2024. So as soon as the contract was over, Lordship, there was a letter from the director to the district authorities, district social welfare organization, to take over the Mission Shakti, that means one-stop centers. And their Lordship has already been, already perused this order also. There was a line there that till the selection process are complete, the persons who are working presently, they have to be continued till that time. Thereafter, Lordship, their termination notice was issued. So just before the period of 60 days, they did not immediately come, Lordship. They waited till June 2020, June 2020, 20th June 25, Lordship, because their termination was supposed to be over on 29 June. And the selection interview was to be taken place on 21st or 22nd, Lordship. Walk-in interview was there. The petitioners, there was an open advertisement. The petitioner did not participate in the selection process. They have not applied for the post also, Lordship. Then, Lordship, they did not challenge, Lordship. So as per this page 68, Lordship, that in the writ petition itself, that their engagement, this was for a stopgap arrangement. We already have stated in our petition and in the affidavit also. And this was there in the letter that has been given by the director to the district authorities, which is in page 68 of this, 67 of this writ petition, Lordship, 1665. Regarding handing and taking over of one-stop center and recruitment of staff thereof. Lordship, so according to this, in page 68, Lordship, the column G, the existing staff of OSC will be continued till completion of the engagement process of selected candidates. Page 68 of this writ petition, Lordship. Then Lordship had there's 26 to 24 letter, Lordship.
Why was a decision taken to terminate them?
No, there is no decision terminate, Lordship, because they were the staff of an agency, Lordship. Earlier, the contract was between the NAVARD and the district administration.
I understand that.
And they were, as per Lordship has already perused their appointment letter. Appointment letter was given by the NAVARD, Lordship. They were never faced any selection or any work-in interview or any sort of screening, Lordship, before their engagement into the district. So simply because of this 26 February 2024 letter, Lordship, when the director has written the district social welfare officer, Lordship, that the handing over and taking over of this and the new selection has to be taken place, Lordship. So accordingly on 4/3/25, the notice was floated for interview of the selected post. The petitioners, they did not choose to participate in this one, and rather they were before this court, and this first this 25/3/25 order was passed. Then they filed one writ appeal, which was in 2005. Then after deliberation, Lordship, when the Honorable Court was supposed to dismiss the writ appeal, Lordship, then they withdrawn the writ appeal, Lordship. They want to seek liberty before the single bench, Lordship. This was there. So, Lordship, the employment of a contractual employee is bound by within certain specific period. So their period of engagement actually has been over when the contract was over between the contract period was over between the district administration and the NAVARD agency. Lordship, then they are before this court and the Honorable Court has protected this. But Lordship, without participating in a process, they are challenging the selection, Lordship. And that apart, Lordship, they do not have any right for extension also, Lordship, merely on the ground that they work beyond this period. And this is completely on a humanitarian ground, Lordship, they have been paid. Because I also have gone through some similar cases in some other parts of India, Lordship, state, where this has not been entertained, Lordship, where the petitioners, they have, the district administrations have availed service, but they did not pay also. But here, at least on humanitarian ground, when as this is their Lordship, that during the stopgap period, they have to, their services will be taken and till the selection process is complete, Lordship. So it is not that the employer may choose to extend or not to extend, Lordship. This is up to them. But Lordship, they also do not have, the petitioners do not have any inherent right, Lordship, to challenge this and they to continue in the same post without facing any these things, Lordship, facing any screening test or anything like this. Because the one-stop center, these Sakhi, these are also...
Were you prevented from appearing in?
No, Lordship, no.
So, Malad, yes.
It was no.
Malad, in the IA, Malad, they have said, Malad, that they will not be. IA, Malad, that page number 18, Malad, they proceed, actually. They say that they could not take into action against us.
Lordship, this is separate thing, Lordship. This is the one query was raised before your Lordship when the matter was heard in June, Lordship, before the summer break. I thought that because they were not our employees, because they are not running the centers properly, Lordship. We have report of this.
Where is the page 18? Where?
Page 18, Malad, last para, last sentence, your office, Malad, see. NABARD implementation. Therefore, no punitive action can be taken against them.
Yes.
Prior to so and so, if any decision arise regarding the employment was appointed by NABARD, the modus operandi was to inform so and so.
Yes.
And there is no, that's last sentence says, there is no provision with the district administration Borpeta to issue so-called notice to any of the staff to terminate them.
Yes, Lordship, because they are their employees, NABARD employees, Lordship. How can we?
No.
Because the
we wanted to know is that in terms of the advertisement, did you submit your applications?
No. Malad, they no question of submitting, Malad. If it is open, Malad, they say that the existing employee can also participate.
No,
Malad, that is not there, Malad.
No, that is not there, but fact remains that you are on a contract basis. Your contract was executed with your earlier employer.
Malad, that we can also see the actor status.
Lordship, shall I finish mine?
No, that's okay. We are trying to understand the
Lordship. Yes, Lordship.
The contra submissions.
Yes, Lordship.
The question is that on one hand, they say that they were continuing. On the other hand, there is no specific material placed by the state to say that their services are not worthy of being retained.
Lordship, this letter of 26 February 24 is very clear, Lordship, which is in page 67 of the writ petition, 1665.
67.
Yes, Lordship. Regarding handing and taking over of one-stop center and recruitment of staff thereof.
Which writ petition? 1665.
Yes, Lordship. In page 67.
Yes.
This letter of regarding handing and taking over of one-stop center and recruitment of staff thereof, Lordship. And the next page in para G, Lordship. It is there. Existing staff of OSC will be continued till completion of the engagement process of selected candidates.
Correct, but where does it say that existing staff is also permitted to participate?
Lordship, how it can be? This is their own choice, Lordship. If it is so that they applied and they were debarred from appearing in the interview, this was something else, Lordship. They have not participated, Lordship. How they can say that they can presume that this and that will happen, Lordship? There is no bar to participate of their participation, Lordship. It would be other way around, Lordship. They applied and they were not, their applications were not considered. They were barred from appearing in the
But if you have
interview.
already taken a decision that they should not be allowed, then in spite of their participating, they may not be selected.
No. They should not be allowed. Nowhere it is stated and no decision of that sort or any instruction of this kind, Lordship.
No, but this letter of 26th of February
Lordship.
doesn't talk about allowing these employees also to participate.
This is
The paragraph at G
Lordship.
rather suggests the other way around, that existing staff will be continued till completion of the engagement.
Yes, Lordship, it is there. But they also know that they are the temporary staff. When they know that their position is not that of regular footing, Lordship, it was their duty to participate, Lordship, and it would have been something else, Lordship. Lordship could have interfered that they participated, they debarred from appearing, they were not allowed to join, sit in the interview. This would have been something else, Lordship. Without participating, how they can say that there should be some instruction?
Where is that?
Because they were not their employees, Lordship. This was an open advertisement.
No, correct.
This was an open advertisement. Anyone can supply, whoever that means qualified, fulfills the criteria,
Where is that
Lordship.
advertisement again? Advertisement.
Lordship. I think this is not in this.
Yes, page 64. Page 64, 165, page number 65.
Yes, Lordship. May I read, Lordship? Advertisement for purely temporary and contractual engagement at the one-stop center, Borpeta, so and so. Applications are invited from eligible candidates who are the citizens of India and fulfill the eligibility norms of educational qualification, experience, age, etc. as mentioned below, against each category of purely temporary contractual posts of one-stop center under Mission Shakti for Borpeta district. Interested candidates having the requisite qualifications and experience may submit the applications mentioning the name of post at the drop box kept in front of the office chamber of the Additional District Commissioner SW Borpeta, room number 9 from so and so. During the office hour, interested candidates are requested to submit their CV along with their self-attested necessary documents as follows: educational qualification, age proof certificate, voter ID, Aadhaar card, experience certificate. The shortlisted candidates will be intimated about the selection process through the personal email IDs of the candidates. No TADA will be provided to the candidates. The candidates must be of minimum 21 years of age as on 1/1/25. The candidates should mandatorily provide their personal working phone numbers and email IDs. Post details, central administrator, then the case worker, counselor, so and so. So any matter which is not specifically mentioned in this advertisement will be decided by the selection committee. The authority reserves the right to cancel, postpone the advertisement without assigning any reason thereof. The post of center admission so and so are transferable. Center admin has to reside within the one-stop center. So this is important, Lordship. Any matter which is not specifically mentioned in this advertisement will be decided by the selection committee. So had they been, that means applied for this, these are the selection committee which would have considered these things, Lordship. Their participation, whether they can participate or not to participate at Lordship.
Yes.
There is nothing on record that debarring that they cannot, whoever, because experience certificate is also, they are well experienced, they could have, that means, prefer to apply for that post, Lordship, because experience also matters a lot, because the experience certificate has been given preference also, Lordship. documents which were required, Lordship. So having not participated in this, Lordship, how they can stall this? And being a employee, they are not even the employees of the district administration, Lordship. And this is completely on the basis of the, as already there was a decision of taking selection of the post. And these are the temporary posts. These are not the permanent post, Lordship, because these are on the of the Government of India project, Lordship. And these are completely funded by the central government. The district has no role other than implementing these things, Lordship. And the districts, all the districts, these centers are operating. And this was actually the Government of India initiative, Lordship, is there. Lordship, on that, I just got a of same nature, Lordship, one judgment of the Central Administrative Tribunal, most probably as these are centrally funded, Lordship. In other state, they approach before the Central Administrative Tribunal on the same issue, same issue, Lordship. Principal bench of the Central Administrative Tribunal. Lordship, I am first reading paragraph 3, Lordship. Paragraph 3, I am reading, Lordship. Respondent number 1 issued an advertisement on so for filling up the 27/7/21 for filling up the post of Center Administrator, Case Worker and IT Worker DO at OSC in Southwest District, New Delhi, and IT Worker. The applicants being qualified applied for the said post and were selected after due process of selection. The applicants joined the post in the year 2021, and since then they have been working continuously. It is alleged that despite this extracting the work from them, the respondents have failed to pay salary from August 21 to February 2022 and from September 22 till date. Besides that, the expenses amounting rupees 50,000 approx for the OSC had to be borne by the applicant number 1 out of her own pocket, and the same has not been refunded to her yet. Instead of releasing their salaries, the respondent number issued an impugned advertisement dated 12/12/2022 for the post against which the applicants are continuously working. Then, Lordship, the prayer portion. Then, Lordship, paragraph 13, Lordship. We have heard the counsel for the parties and also perused the documents and record. The impugned notification advertisement is for engagement of staff in Sakhi One-Stop Center. The notification has been issued by District Disaster Management Authority. There is nothing on record to indicate that the applicants herein are debarred from participating in the walk-in interview mentioned in the said advertisement. No doubt the applicants are already working in the center, having been engaged earlier. It is not disputed that their engagement has been strictly contractual. Therefore, they cannot claim any vested right to be engaged, appointed on a regular basis in perpetuity. Then, Lordship, paragraph 16. OSC Sakhi is a unique scheme for specific purpose. The genesis of establishing this center is the tragic and shocking incident recognized as Nirbhaya, which had shaken the conscience of the nation. The objective of setting up these centers is to provide shelter, legal, medical, and counseling services to victims of gender-based violence. This is in tune with Article 1 of UN Declaration on the Elimination of Violence 1993. The 12-plant working group on women, agency, and empowerment had recommended setting up these crisis centers on pilot basis, and accordingly they have been set up in the Union of India through the Ministry of Women and Child Development through a centrally sponsored scheme.
Do you have the judgment of Pyara Singh with you?
Yes, sir. I
So here
Here Pyara Singh has been also discussed.
Here grounds are same grounds.
Same, Lordship. I have got this.
Thank you.
There are other cases also which are
But
all
you're not
before the
raising-
Central Administrative
You're not
Tribunal.
raising an objection that the matter should have been filed before the gap.
Lordship. This should come from the central government, Lordship. It is because central government is also a party, Lordship. I also have other judgments, but all of Central Administrative Tribunal of the same issue, Lordship.
Paragraph 44 to 50.
And Pyara Singh has also been discussed here, Lordship. in paragraph 7, it has been discussed, Lordship.
This is in terms of regular employment. Here in the facts of the case, can there be a regular employment? This is
My lord,
the
it may
scheme.
not be, my lord, regular, but
Space
my question
project.
is, my lord, whether this temporary can be, my lord, yeah, until unless, my lord, there is adverse something, my lord.
No, no,
Not be.
the
Correct, my lord.
circumstances are different.
Some can be different, my lord.
There was some contract with some NGO.
Yes.
These NGOs contract was terminated or then forced. Now you're taken over by the government. Now there was an advertisement issued. You have chosen not to participate in the.
No, well, we have challenged that advertisement. Moreover,
That's
my lord,
right.
the director written that our services will be terminated.
No,
My lord.
you have challenged it,
My lord.
but you did not choose to apply.
Lord,
You have challenged it on the
in
ground
the
that
we cannot then challenge it, my lord. That is a question also. We could not have challenged it if we had participated, my lord.
no, we are not on that. What
Yes.
we are is that there is no dispute that you are a contractual employee. The agreement or the contract which you had executed with your employer
My lord.
is no longer in existence.
No.
Because that employer has been.
Yes.
The responsibility has been taken over.
My lord.
Now, in order to call out a right to say that this agreement should continue, at least till the remainder portion period mentioned in the agreement, you have to show that the agreement is for 3 years, 4 years, 5 years, and the respondents are.
Not on that. I'm not on that, my lord.
Your
I want on
primary
this,
claim
my lord,
is that you are a work charge casual employee, temporary employee. Now this advertisement is also for temporary employee. But there cannot be a regular employment here in terms of the Piara Singh's judgment. Because this is not a regular government department.
Not.
It has to be on a contractual basis. And you have chosen not to appear. Now, how will the government decide your suitability without you submitting to a selection process?
My lord, the main thing is this, my lord, in the committee meeting, my lord, in the IADM annexed, they say that they cannot issue the notices. My lord, if there is some adverse remark against me, my lord, that should have been, my lord.
Not till that extent you are not affected. But is there anything, if you can show that the committee has already taken some decision to come to a finding that you will not be retained? Is there anything that you can point out from the notice agreement or circulars issued?
Committee, my lord, that committee also, my lord, I am challenging, my lord, that who has formed the committee and who are the persons, my lord. I have already placed.
The committee's members are reflected there in some.
Yes, Lordship, page number 18 of the IA, Lordship.
It is there.
Yes,
18, my lord,
Lordship.
but if you also see, my lord.
Where is the scheme? Where is the scheme?
Page 21, my lord. Scheme, yes.
For the IA.
Scheme, my lord, is in the next case, my lord.
In the writ petition.
It's 3476. 3476.
21.
Yes. Page 53. Page 53. 3476.
53.
53.
No, it's not 50. Sorry, this is the IA.
District level committee in page 53.
50.
In WPC number 3476.
If you see the district level committee,
yes,
it is to be officers in charge of the women and child department.
Yes, Lord.
Number one.
Yes.
Other members to be nominated by the DM or the DC
Yes, Lord.
from departments like education, health, police, skill development, banks, etc.
Education is there, police is there,
Now,
Lordship.
Where is that decision? Where is the member
Lordship, in page 21, Lordship, kindly may see.
of the same?
Of
petition?
the, no, Lordship, of the IA that has been filed by 1665 on the Lordship.
Page 21.
Page 21, my lord, your lordship, see. My lord,
See, one is the
21.
district commissioner,
my
then
lord,
the.
SP of Barpeta, then CEO Jila Parishad, then additional district commissioner. This is as per this one, Lordship.
TDM.
Yes.
DSWO.
Education Department, then additional SP, DSW, Barpeta. They are all this.
From the scheme, it is not clear that the district level committee has to be framed by the state level or something
No,
like that. Nothing like
Lordship.
that.
But my lord,
Because
the
scheme is
selection
simply
committee,
the district
selection committee
lordship.
has been formed by them by the director.
It has been framed, Lordship.
My lord,
It is framed.
No, selection committee is in respect of the interview. I'm sorry, the
yes,
the advertisement.
Yes, this.
Advertisement, but-
Yes, Lordship.
that is, yeah. Advertisement was issued by the director.
No. You mentioned about selection committee for.
That is page 62 of the district petition, my lord, second petition.
In this 1665, also
No.
page 69, it is there, Lordship. Selection committee.
Page 62 of the second petition, my lord.
This selection committee is for what?
This selection of this workers.
Recruitment functionaries.
Yes. One-stop center, Lordship. Recruitment of functionaries.
This is
one-stop
only
center.
for the post of multi-purpose worker and security guard. Multi-purpose worker and security guard. In the vacant post. Like a vacant post.
This is not the vacant post.
No, but you have to color your right that you are, there is some right which entitles you not to be discharged. What is that right? What is that right? We can't think of, we can't find any right that your right can be under a contract also. That you are.
No, right, my lord, only my lord, that's down, my lord, that the Supreme Court I have submitted, my lord, Jaggi, my lord.
Pyara Singh.
Jaggi.
Jaggi. That is also in terms of.
They are selected by a committee, Lordship, not by any private
That
organization.
is also for.
Yes, Lordship.
Regularization.
This judgment will also not applicable in this case, Lord.
You cannot, you are not disputing that you are an employee under the contract.
No.
There is a contract agreement as far as you are concerned.
My lord.
It is not your case that this contract is for a particular period of time. Let us say 3 years, 4 years, 5 years.
No.
And during the interim, the government had taken over the institution. Now they are proposing to relieve you before completion of the contract period or nothing like that. Notice was here, court permitted to issue 60 days notice. That is also done. Advertisement, you did not participate. There was no.
Advertising, my lord, at that time, my lord, that is the main question, my lord. We could not have participated that time. And nothing has been said in the, my lord, that the existing, my lord, persons can also participate.
All right, we'll dictate orders tomorrow.
My lord.
Lordship.
Heard plates tomorrow for orders. Tomorrow.
Simply above.